Lordship, in this matter, Lordship directed to take instruction from the government to consider the possibility of forwarding the matter to the HPC, Lordship. I have forwarded the matter to the same, to the government, Lordship, and government has placed the same before the Honorable CM, Lordship. Now, only difficulty is, Lordship, presently due to the flood situation, Lordship, he is unable to, take a final decision on the issue. So in that regard, Lordship, I am praying for some time, Lordship. And one second aspect is there, Lordship. So far as the applicability of this particular judgment in respect of the present situation, Lordship, that is also presently under examination, Lordship. I am trying to go through the judgment, both the judgments, Lordship. It appears to me, Lordship, it appears to me this judgment is not applicable to our situation.
So you mean to argue? There are two aspects. One, you are saying that matter is pending before the CM.
Yes, that instruction is awaited, one. And Lordship will consider.
You are contesting on the applicability of the judgment.
Lordship will consider that list. So on that point, Lordship, I would like to.
Moment I decide on the second point, then I don't leave option to the CM to decide.
Yes. Pardon, Lordship.
The moment I decide the second point, I don't leave the option to the CM to decide.
Yes, that is there.
So you want to argue on the second point?
In spite of, if the government, independent of the judgment, Lordship, want to take some decision, Lordship, that is why I'm praying.
Therefore,
Lordship.
I'm saying you want to take adjournment on the ground that the CM is presently looking into this aspect, it is okay.
Yes.
But if you want to say both things, then it's a different thing.
That is for my personal,
As such, we do not have any objection regarding Milord. If somebody is in head of the state is in otherwise busy, Milord, we can appreciate. But end of the day, Milord, our limited prayer at this stage is let it be referred to the Milord Rehabilitation Center. In the meantime, Lordships can, otherwise matter is dragging on like this. The end of the day, the health of the animal is in not good shape. Though, Milord.
Okay. Now, you see,
of course, 1 or 2 days will not make any difference because you have already waited.
I'm not praying for much time, Lordship. Next week, Lordship may take up this matter.
We'll have it next week. And in the meantime, let him get his instruction.
Milord, I understand
But you see,
owner of the
HPC is a specialized body.
yes.
HPC is a specialized body. As to whether you have a right, you don't have a right, they have a right, it is to be adjudicated by them. And the matter thereupon will be placed before the Supreme Court.
No difficulty, Lordship, but only so Lordship will consider. Lordship, here the HPC is constituted only for the specific purpose of transporting animals to the camp owned by the Respond Number 3 Trust, Lordship. That is the trust registered under the Gujarat Society Registration Act. That is my limited understanding. To my limited knowledge, Lordship, that is the proposition that has been laid down in these two judgments, Lordship.
Paragraph 8 of Murli's judgment, though the scope of the jurisdiction of the High Power Committee was limited by the High Court to transfer the elephants from the northeast part of the country to the elephant camp of the Respond Number 3.
Yes.
We see no reason to extend it to Pan India, particularly when by extending the jurisdiction at Pan level will not only serve the real public interest and would also advance the cause of welfare, care and rehabilitation of wild animals, but will also curb the filing of frivolous PIs before different lines.
Lordship. In the first judgment, Lordship, it was from Tripura and Arunachal, and it was only in respect of 23 numbers of elements. Now it is Pan-India, Lordship, from any state to the camp of the Respond Number 3.
Because here the jurisdiction as per that judgment and further the subsequent order which has been passed, thereby extending the limits of the High Power Committee further.
Yes.
Reason. Anyways, we take it on that aspect and thereupon, after 1 week, we will take it up and then we'll decide it.
Lordship.
But I am inclined to refer it to the HPC.
Yes.
Lordship will consider this judgment also, Lordship. Lordship will consider my submission.
Mr. P. Naik, the learned additional advocate general. submits that in pursuant to the order passed by this court on 21/7/2026, the respondent, he had the judgment order dated so and so, the learned Mr. P. Naik, the learned additional advocate general, appearing on behalf of the petitioner, submitted that in pursuant to the order dated 21/7/2026, the instructions are awaited from the state of Assam in respect to the query so made, inasmuch as the question, inasmuch as the said aspect is being presently looked into by the Chief Minister of Assam, and he is otherwise busy on account of the floods. He therefore submitted that a week's time may be granted to the petitioner. Mr. Taking into account the above, list this matter again on 11th of August 2026.
Lordship, may kindly make it on 18th, Lordship. Just 1 week, Lordship. 2 days.
18th August 2026 to be listed at the top of the list.
Obliged, Lordship. Obliged.
Totally cited to
My lord, my senior is coming, my lord. I am.
What is your case?
My lord.
What is your case?
My lord, yes, my lord, this issue that I am challenging the notice which was wrongly issued by the authority, and thereafter in 2007
What are you challenging here?
challenging, my lord,
My lord,
this,
actually, my lord, his page
Lord.
118 and extra 21.
You are challenging an order passed by the Board of Revenue.
Yes.
my lord.
See, why you are referring to another page 118?
My lord, initially I filed this case along with the my lord revenue appeal and condemnation petition. Thereafter, my lord, this is allowed. Subsequently, learned friend opposite party filed this writ petition, and writ petition are remanded.
Yes.
My lord, this notice was issued in 1991. Is a wrong address and unserved, my lord, this notice.
I'm not on that. Here the question is that the Board of Revenue should have condoned the delay of 16 years. That's the issue. Because you have approached the Board of Revenue after 16 years.
My lord, this my my lord, my
Me one thing,
AU Chaudhary is coming, my lord. My senior is AU Chaudhary.
Huh?
AU Chaudhary, my lord. He's now he's another court coming, my lord. He's argued the case, my lord. In this case, my lord, the issue, notice was issued.
My lord,
Mr. Counsel, you should have challenged this order. Why didn't you challenge the order passed by the learned coordinate bench in the year 2013?
My lord, my
Because your appeal it was not an appeal, it was an application filed under section 151. The application under section 151, there is no limitation. But I am now bound by this. Problem lies there.
this honorable court passed the order remanding the matter and subsequently my
So you
condemnation
should
is
have
dismissed.
challenged this order.
my lord, they have filed it under section 81. That is,
But he has used 151.
yes, yes.
151 is
Read with 151, but
whatever
application,
may be,
yes.
151 doesn't have limitation.
but application was under section
When you see
80.
the impugn order at 118, this is an appeal against the auction sale by the so-and-so. The appeal was allowed by the so-and-so.
My lord, may I just point out one document, my lord?
Huh?
At page, my lord, 56. 56, my lord. This is their document, my lord, annexed with the petition. My lord, here, after the process has been completed, I have been the bidder and we have submitted the money. Thereafter, they have gone for annulment of that order way back in 1994. This order is not challenged, my lord.
This was filed by whom?
This is filed by the petitioners, my lord. See, in the report of the Tehsildar has delivered over the possession of the land to the auction purchaser, and the auction purchaser put his signature in
Yes,
the
who
warrant.
is arguing the matter.
Yes, yes.
This case, Bharat, I had a land banner that was auctioned in 1991 because I did not pay Khata. But notice was not served to me, served to somebody else.
I'm not on that. I can't look into that aspect. Problem lies because of Justice B.K. Sharma's order.
Yes, yes.
In application under 151, there is no requirement of a limitation.
Yes, yes.
Okay. That order has been passed thereby directing them to look into the question of limitation. Now I am bound by that order,
Yes, yes.
and you have not challenged that order.
That part is there, Bharat.
If you have not, you should have challenged the 2013 order because there are numerous judgments of our High Court that in respect to 151, there is no limitation. But you have not done so.
No, yes, of course.
Now, because of that, now the question arises on the question of limitation.
Yes, yes.
So when the limitation order was passed, this aspect ought to have been taken note of. Problem lies because of you have not challenged this order.
Yes, that part is there, Bharat. But here, once the matter is remanded back again, Bharat, before the Land Board of Revenue, Learned Board of Review member did not go into the merit, did not go into the, yes, fact of the case,
It's
circumstances.
not required because the only direction was to
For
look into
limitation,
the
for
question of condonation.
Yes, but that aspect also has not been properly considered because according to him, my lord, in 1994, we have filed an application. But we never filed any application. The order sheet also reflects that is, there is no sign and signature of 1994, and that application is also not available with the record, my lord. That is apparent of the face of things. Can you see the order, my lord, in order, my lord? The landed member board, my lord, board of review himself said, my lord, in 1994 application, according to him, by which the matter said to have come to my knowledge by 1994. But that order, that application is not available with the record. And the order sheet I have annexed, my lord. Order sheet also does not reflect matter 1994. There is no signature seal, nothing, my lord.
Now tell me one thing. 1991, you have filed the auction had happened,
Auction, yes.
meaning thereby, prior to that, your land which was there, the DAG number or the patta number which was there, on account of non-payment of the rent and non-payment of the lease,
Yes.
they has been put to auction.
Yes.
Thereupon, after auction, it was given to them.
Yes.
Did you not take note of, or did you at any point of time deposit the land revenue for the 16 years? My question is this.
It is not that we have paid land revenue receipts is there, my lord. But thing is that
No, my question is, did you pay land revenue during this period?
land revenue we paid.
Obviously, you could not have
Yes, sir.
paid because the number,
Yes,
the
sir.
name has been changed.
Yes.
So if the name has been changed, the ownership has been changed, therefore, you cannot.
But
pay.
here interestingly, my lord,
Now, I would have understood 1-2 years gap or 4-5 years
Yes,
gap
yes.
is okay, but we are concerned with 16 years.
yes, 16 years. Yes, sir. Here, my lord, the notice was not served to us, my lord. It is
Again,
different.
I'm not going to
Oh,
go
that
into
period,
that.
my lord.
Once the auction sale had happened,
Yes.
the sale had happened and thereby the land is given to him.
Yes, yes.
Now his name has been entered in the record of rights.
Yes.
There's no quarrel with that proposition. If the record of rights, their name, I would have understood, okay, you may not have looked into the record of rights. You were always under the impression that
That
it
is
was
my
in your
land,
name.
yes.
But did you pay the land revenue for these 16 years?
No, in this day, but prior to that, I paid, my lord.
When? Prior to 91, I'm not
Yes,
concerned.
sir.
I'm after 91, I'm
After
concerned.
2007, after this one. And one more point, my lord. According to us, we come to know only in 2007, my lord, when we have filed application. The event that, my lord, suppose we did not pay, my lord. Now, we have been, should have been properly dealt with, my lord. Notice has been served to us.
No, Mr. Cho, that is not the question. My question is to find out that you say that you did not know,
Yes, yes, yes.
meaning thereby you did not pay the land revenue
Yes, yes.
from
Yes,
1991 to
this period.
2007.
Yes,
And if you had paid, you would have known that.
yes, 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 yes.
So therefore, when you have yourself not paid the land revenue out there, all this while, what occasioned you to pay in the year 1997 and ask for a mutation in your name?
Now, in 2007, we have come to know, my lord, regarding
Why? Because what happened during these periods?
regarding this also, because these are, my lord,
So therefore, the question cannot be said that you had no knowledge.
knowledge we have come to know in 2017, 2007. That is a fact, my lord, what we have stated, my lord. That is our pleaded case, actually.
No, you cannot merely say that I came to know.
Yeah, the statement is there. According to when we come to know, immediately file an application in 2007. my lord.
Because how is the
$93. $93.95. $95. $95. $95. $89.95. No. 90. 18 or 13 the Malamas.
What is the price at which you have purchased? How much land?
Malad?
801.
17?
Huh?
Please, 801.
How much land?
Land is around 17 bigha, 1
One
kotha,
kotha,
15
15
lesson.
lesson.
It's Marcy land, my lord. In the year 2091, 1991. Page number 54, my lord. We have paid the entire amount.
One more thing.
No way out.
Malad, one more thing, man. Even if I don't pay, Malad, that is, I'll be penalized. That is all right by the department. That's all. Even then, am I not entitled to receive a proper notice, my lord, for hearing of this, my lord? Because auction was made, my lord. Notice was not served to us. Similarly, with a person having
So
given
therefore, what happens if the auction was made
this
and notice was not served?
notice.
Should they file the civil suit
Yes, that I did
as
not
per
find
for annulment?
annulment.
Now, you did not do so. You could have gone under section 79 also.
Yes.
You did not go. So therefore, in the meantime, rights have accrued.
Apart from that matter, the final order by the liner board of revenue, he relied on a facts matter which is not available on the record matter. He said regarding my knowledge of 1994 matter, that is not on record matter. Order sheet is there matter. There is no signature in the order sheet matter.
Hmm?
He relied on the record where my lord the officer's signature
Who
is
has
not there.
produced this document? Annexure 10 series? Before the, what is your name?
My name is my lord Sofi Rahman. Initial at that time his name was his father's name.
What is your father's name?
Father's name. Rustom Ali Sheikh.
And who is Gunaruddin Sheikh? Huh?
Actually my ancestor's name is Gulabdi Sheikh. Gulabdi. That is page 31, my lord.
Page?
Page 31. Wrong number notice.
Gulabdi Sheikh.
Notice was
And
served,
what,
my lord.
what about this original
And,
order?
Kindly see the notice was served page 38, my lord.
I'm not on that, I'm not.
In a different name.
You leave this court. No, Mr. Hazarika,
My lord.
kindly say you are referring to page 55,
Yes, 56.
56. This
Yeah.
is a case against some Gunaruddin Sheikh. Who is Gunaruddin Sheikh? Where is the original copy of this?
Original photograph.
Hmm? Who produced this document? You produced this document before the Board of Revenue. He never produced this document.
Original classification. Original. Cancel.
My lord, I had photocopies at that point of time. The record is with
You
me.
mean to say on the basis of a photocopy,
No,
the
yes.
Board of Revenue passed that order without calling for the records?
My lord, that is the probably.
Now, so from the photocopy, whose name appears?
My lord, the same order that is at
Understood. Whose name?
Gunaruddin.
Now, who is Gunaruddin?
That Gunaruddin,
No problem. Şuna bıraktım ben. Şuna bıraktım ben. Bunu konuşalım. Bakın. Ulan.
38. Page 38 comes up. 38. Gunaruddin Sheikh, father Ahad Ali, settler's name.
Type copy it. Just that for
इस वाले से बंद है.
original man just should be. Minimum of the full pushing. I think I could put that on. Minimum of the full pushing. Minimum of the full pushing. I took that for it. Notice this. What is the stuff to do? I mean,
Here, the certified copy. This order is against some Gunaruddin Sheikh.
Yes.
Gunaruddin Sheikh has nothing to do with him.
yes.
My lord,
And what is Gunaruddin's father's name?
Ahad.
Ahad Ali.
Huh?
Ahad Ali. Page 38, my lord, the next one. Document. No, certified, right? Original.
Who are you?
My lord, these petitioner are my lord.
You have purchased it from
Yes,
those
they-
owners.
From Gulabdi Sheikh. Gulabdi Sheikh. His father name is late Jahad Sheikh. Notice ought to have been sent to this Gulabdi Sheikh and us.
To you.
Yes, Gulabdi Sheikh.
You purchased in the year 1985. And the notice was issued to whom?
Notice was issued to this man, my lord, Gulabuddin Sheikh.
Because Gulabdi Sheikh and Amrit Ali Sheikh
Yes,
are the sons of Jahad Sheikh.
Jahad Sheikh.
Whereas the notice was issued to some Gunaruddin Sheikh,
Gulabuddin Sheikh.
son of Ahad Sheikh,
Ahad Sheikh.
Ahad Ali.
Ahad Ali.
And that case is filed against Gunaruddin Sheikh.
Gulabuddin Sheikh.
Now, who had filed that application in the state of Assam versus Gunaruddin? Seems that Board of Revenue have not looked into that aspect. And you purchased from,
Gulabdi Sheikh.
and your names were not recorded in the record of rights. Huh? Where?
Page 29, my lord. Is there, my lord?
So you were not issued notice,
Not.
although your names were there.
Yes.
Entered when? When the notice names were entered?
Enter down below, it is
85.
dated 21/1/84.
1985.
80 years.
And in this case, notices were issued when?
91, my lord.
91, madam.
It says, my lord, the processor has submitted the report that he could not serve the notice to the patadar since he did not find him in the concerned village. Therefore, let the notice be served again by hanging it.
But there was a Bakita proceedings.
Yes, my lord.
This document is there, na? I was asking you that document, why haven't you mentioned me? Kindly see your land revenue paying receipts.
Ma'am,
You have it?
yes, yes. Yes, ma'am.
Have it?
Yes, ma'am.
Annexus 6 series, which you have made it in the appeal. Now kindly see this document, the first document. This is the payment of land revenue from 1982, 83 to 86, 87,
Yes, ma'am.
made on the year 1989. Do you have it? Okay.
Yes, I have to
Now
copy.
here it is seen, Tarpora Puahol. Whose name it is there?
Six, eight, one.
But I think our Babe
Annexer six.
Puahol. What is this?
It is written here, Gunaruddin.
So, huh?
It is seems written Gunaruddin.
Gulabdi. This is Gulabdi Sheikh. You have it? Mr. Counsel, you are not prepared with your
yes,
case.
the type to be.
Very poorly preparing.
Yes, yes, I have the copy. But this,
Not preparing properly.
I'm sorry, madam. Actually,
It's very sad.
in I have come running, my lord. File was here, madam.
For last half an hour, you are still running.
No, no.
Then? And what were you doing back home? You didn't prepare this matter.
I prepared
I'm
yesterday.
trying to help you out and you are not helping yourself. This court is not here to help you out further than that. This is for which land? What is your dark number? Very difficult, not preparing it properly, Mr.
Yes, yes. I'm sorry, ma'am.
Very unfortunate. Should I appoint an amicus? No, I think so. You are not helping the cause of your client. Let me appoint an amicus. I think we'll appoint an law intern as an amicus. He will be better off.
Protean number 56.
Its Nokia number is here, my lord. The number
That number.
Dark number is how much?
Tag number, my lord.
201/204.
208, yeah. 208 in English, which is written, my lord. 208, my lord.
Now, these documents, these,
Patan-
land revenue receipts do not mention which tag numbers. Why?
আমি যে দিয়েছি।
Tag number, it is written, my lord, on the third column, my lord.
Where?
201, 204. Then, my lord,
Where do I get it?
208. My lord, page 31, my lord.
এই যে দিয়ে নাও।
Page 31. Page 31, middle portion, my lord, old and new, my lord. 201, 204, and new, 230.
No,
my
no,
lord.
no, no, no. Show me the original, not this
Yes,
one.
yes, yes. This one, my lord, page 34, my lord.
What is this?
Page 33, 34, my lord.
No, page 31. No, where is the land revenue paying receipt?
Yes, sir, yes. Page 31.
ঘুরেছে রে। Yeah.
It's a line between. I have the original copy, my lord.
Mm,
The original
No, in the original copy, is there dark number mentioned there?
tag number is not there, my lord.
How do we know that these payments were made against these dark?
This Toji no, my lord, alia.
Huh?
Subsequently, tag was made, my lord. The Toji number is there, my lord.
No, if it is a tozi, obviously then it is not your land.
Subsequently, it has become, my lord.
When did it become your land? Your land was prior to that. Show me. Can't be tozi. Why are you saying this to be tozi? These are not tozi.
एकदम मुखबाट को बनाले बस्यो रिसिट हो गयो सर खाना रिसिट
রোজি থাকলে দিন
These documents are different from the documents which you have enclosed to your memo of appeal before the before the court.
मुख खाली गयो
Because these documents do not mention the English number.
yes English number is not there
Why is it here in the original memo of appeal filed before the authority?
because that is a type copy of this two, my lord. The
Can't be true.
34 page 33 and 34 type copy is 29 31, my lord. So it indicates the dark number, my lord.
But these documents do not mention which are the dark numbers. Pattern number. It is different. 1394, 1395. This is the year put. No dark number, pattern number against this. Show me the original documents pertaining to your land records. You can grade you, okay?
Send it. Yeah. It was.
My lord, one, that order sheet of 1994, my lord, I've gone through the records. It is their document, my lord, before the Board of Revenue.
Obviously, that is not their document.
My lord, in the appeal, it is,
You have given the document by yourself.
no, my
You
lord,
have given.
it was annexed, my lord, page 65.
Huh?
Page 65 of the memo, my lord. Appeal memo. Before the board on 2007, my lord. They have annexed it at page 65. I have referred from that. I remember, my lord, now. It's a long back, my lord. I was there in the revenue board, my lord, that point of time. Page 65 of the appeal memo. It was from the record absent. नहीं, अपना appeal से line please. वो appeal memo का सही. यहाँ पे ना, बना फोटो. 97 of. एक मिनट. आगे ना. एक मिनट. अपना report को विजिबल. You have a piece to buy, no? Yes.
No. He has not enclosed to those documents. He has mentioned about those documents, but he has not enclosed those documents.
My lord, this is the appeal memo, my lord.
I am reading that appeal memo only.
Yes, my lord, at page, yes.
He says these things, but
Yes.
you see, Boinama, he brings the 103. Brings the certified copy of the 103. Okay.
Yes.
Then the last order, he has also brought the certified copy of that. When was the certified copy taken? Let us see that.
My lord, page 65 of the 2007 memo, my lord.
So how do I know that what is the date of the certified copy?
No, no, not that, my lord. My lord, the original appeal
Okay.
memo, my lord.
No, this certified copy was taken by him in 2007.
Yes.
This order he came to know in the year 2007. This certified copy of this document was taken in the year 2007.
Yes, that's true, my lord. But
But he categorically says that it is not he who has filed it. He has categorically said that, and can you see in his appeal memo,
yes,
more
that,
particularly this paragraph,
yes.
paragraph number 20.
Page 56, my lord. It says. that,
Paragraph number 20.
Paragraph number 20. Yes. They have denied that, my lord.
But where does Gunaruddin Sheikh come in? Gunaruddin Sheikh has no business anywhere. First, one. Secondly, these lands were sold in the name of the petitioners.
Yes.
If these names were sold in the name of the petitioners, and the petitioners' names were inserted in the year 1985, then in such circumstances, forget about issuance of no notice.
Yes.
The board should have taken into consideration as to whether the petitioners had filed their application or not.
Yes. My lord, in that appeal of memo, my lord, 91 order, then 92 order, 94 order, chronologically these were.
Yes,
yes.
enclosed, but all are certified copies taken in 2007.
My lord, I am just referring to that order, my lord.
I
of
have
94.
seen it. Now
Yes.
he mentions it, all these things, but these are certified copies taken in the year 2007.
Yes. My lord, 27.
Look here. I am arguing for the counsel for the petitioner. The backside page of the doc, the last page, last page.
7. That is
It's all
true.
taken in 2007.
True.
Now you see his paragraph number 20.
20 categorically denied, my lord.
He says that I didn't know out there all these
Yes.
things. Somebody has filed an application in our name.
Yes.
But the fact remains that these applications, after the sale being made in the year 1985 to the petitioner, Gunaruddin or Gulabuddin, whatever his name is, he had no business in respect to the land. The application should have been, if the court wanted any other ground, is different. But not have been ground to reject it.
My lord, then I would say, my lord, let the issue be decided on merit then. It may go back, my lord, that much. But since 1994 to 2007, my lord, there is no due diligence, my lord, to find out whether that part is also there, my lord. If they do not
But
know,
if there was a ground taken
yes,
that it is not believable, not on this ground,
yes,
but it is not believable
yes,
that they had notice. First, that there is an admitted fact that there is no notice to these petitions.
yes. My lord, I agree to that. Suppose there were no notice also, but since 1992, when the sale was confirmed, till
Advaita,
2007,
you
yes,
have to also understand
yes,
a right which is being created
yes,
for the land is a right under Article 300A. Can the revenue authority, on account of non-payment of the year,
yes,
take away that right. A settlement can be annulled. They can put the estate for recovery of that amount.
Yes.
Have they offered? How much was the amount
Eh.
area to be paid?
59, suppose some,
93,
some,
93.
around 100 rupees. I suppose.
93.
100 rupees.
No, yes, around that.
93.
Just I'm giving the exact.
It's okay, 100
Exact
rupees.
amount is, my lord, 93 for 11.
93. 93.
Baki total land.
Point
value
11.
amounting to
93 rupees.
93.11
So
of the land.
93 rupees. Now,
Point of time.
the question is, once you recover that 93 rupees, it is also your duty to refund him the remaining. Attempt was made.
Yes.
That's the law.
My lord, my limited part is, my lord, I have contested into the in the bid, my lord. Then a bid was in my name, my lord. I submitted the money on this very day, 801 rupees. Thereafter, yes,
Mr. Hazarika, I'm not saying that you are wrong. No,
yes,
you may not be aware, or you may have been aware, and your client may not have informed you also. But the fact remains, these sales which are being made by the revenue authority, and more particularly nearby, where is that land?
Marat.
now, now under the BTC,
Aramgas, Gauripur.
Huh?
Gauripur, Tehsil Dhubri.
Gauripur, under the, now it falls under the BTC, my
There
lord.
is one matter which I have taken up once. 65 or 70 bighas of land
Right.
sold per bigha at 24 rupees.
My lord.
In 201 rupees per bigha. It was sold. And do you know where the land is? Just after crossing Amingaon. And that too in the year 2001 or something.
That is, my lord, inadequate.
No notice, nothing. I set aside the entire process. We do one thing. There are two ways out. One thing, the Board of Revenue has the power under 151. There are many judgments to their effect, whereby beyond the question of limitation also that can be looked into, because he is the highest authority.
Yes,
Now, that is one aspect. So, irrespective of the, because these are division bench judgments,
yes,
because at that point of time, writ petition used to be taken up by the division bench. If you see all these judgments, these are judgments mostly around 1960, 62, all this judgment, and it has continuously hold the field. Now, in this case, what has happened, the Board of Revenue was only swayed by the fact by these orders. Nothing else.
yes.
I can remand the matter back to the Board of Revenue on the basis of either decide on the merits or ask them to again reconsider taking into account section 151.
I think, my lord, second option,
second one.
second would be better. Because,
Reconsider without going into this, because this, unless the
Yes.
board could have
yes,
looked into these records,
yes,
they could not have done.
yes,
The records should have been looked into, not on the basis of the certified copies.
yes, true.
So therefore, the order, the basis on which the order was passed is bad. That order
That
needs to
much.
be
My
interfered.
lord, then there, if it is condoned, then let it be.
I'm not
Yes.
condoning. Why
No,
should
no,
I?
not here, my lord, in the.
The moment, Mr. Hazarika, you have to understand, the
Yes.
moment I condone it,
No, not here, my lord, not
no,
here.
if I condone it,
Yes,
Where appeal goes,
No.
his appeal is allowed.
That is why, that is why, I'm not saying here, my lord.
My lord,
Therefore I won't do.
Yes.
At the instance of a counsel who is not prepared.
Yes.
I may
And my
allow
lord,
his
my lord has
ability-
rightly said, my lord, suppose 2027 they have knowledge, but they could have they could have filed a civil suit also, my lord.
No. That is why, otherwise I would have put him.
Yes.
See section 82.
Yes. It would be like for the revenue board, man.
So their only way was not a application under 51.
Yes, they could have gone by that also.
They could not have filed an application under 81. That application had to be filed within 1 month, 1 year.
Yes.
And if you go to 82, first it says that annulment can be filed, a challenge to annulment can be made
Civil court.
in a civil court
Yes.
if the requirements, all this notice and all is not being done.
Yes.
Then you can do it. But see 82.2.
82.2. A suit shall not be entertained upon any ground
Un-
unless the ground has been
Any
specified.
ground means
Application.
whatever ground may be, suit cannot be entered. So therefore, in view of that bar,
Yes.
he cannot go to the civil court.
Yes. A suit on any ground.
Only
has
way
been
out
specified.
is 151.
Yes.
So 151, there are many judgments.
my,
What you have heard from me,
yes, yes,
take it out.
yes,
Do it.
my,
My lord, since 2007, now 2026, same issue, my lord.
Huh?
That this issue still persists, my lord.
It will go on because
Yes, yes.
when you purchase land which is much valuable at only rupees 800,
But my lord, those are
91 also 81, 800 was too less for 17 big.
801, my lord. No, 800.
801, okay, 1 rupees add. We make it, I add 1 more rupees, make it 802. But 802 for 17 bighas of land is too less.
apart.
And you are exercising, the only question is that they should have only looked into how much money. It was 96 rupees. And your Annexus 6, which you are there, that is wrong. That is not a document on which you are saying. Because those documents do not mention anything about the dark
Dark
numbers.
number one.
Heard Mr. A.U. Chaudhary, the learned counsel, appearing on behalf of the petitioner. Mr. T.H. Hazarika, the learned counsel who appears on behalf of the private respondents.
81288. 81288.
812.
Hydroli Talukdar died in the meantime, my lord.
Roman 8 Dev. None appears on behalf of the other parties. The present petition has been filed by the petitioners, challenging the order dated 6/2/2014 passed by the chairman of the Learned Assam Board of Revenue, whereby the condonation application of delay was rejected on the ground that the petitioners could not have approached the Learned Board of Revenue after 16 years from the date of the auction sale, and more particularly when The petitioners who were the appellants have filed an application before the additional deputy commissioner Dhubri for annulment of the sale, which was rejected by the order dated 23/3/1994. Full stop. Next, brief facts of the case. Gulabdi Sheikh, Gulapdi, and Amrit Ali Sheikh were the sons of late Jahad Sheikh, were the owners of a plot of land measuring 17 bighas, 1 kata 15 lechas under Khotian number 56, situated at Porbat, Juar, Pargana under Dhubri Tosil in the district of Dhubri. The said land was included in the revenue survey number D737 of village Borbita, Toza, Tozi number 6, Porbat, Juar, acquired estate. The government of Assam acquired the said land, and thereafter the land was included in Khotian number 56. And by an order passed by the Assistant Settlement Officer on 19/1/1965, the lands were settled with Gulabdi Sheikh, son of Jahad Sheikh, under the provisions of the Goalpara Tenancy Act 1929, and new Dag number 204 was created. It is also the case of the petitioners that the old patta number 18 was renumbered as patta number 49. And similarly, old Dag numbers 201/204 was newly renumbered as 213 in pursuance to an order dated 24/1/1985 of the Assistant Settlement Officer. Full stop. It is the further case of the petitioner that the said Gulabdi Sheikh and Muhammad Amrit Ali Sheikh sold by registered sale deed number 4232/1983, dated 18/4/1983, the land to Muhammad Wahidur Rahman, Muhammad Alam Sheikh, and Muhammad Ruhul Amin. The said lands thereupon was sold to the petitioners by the registered deed of sale bearing deed number 5394, dated 9/9/1985. By this deed, dated 9/9/1985, out of 17 bighas, 1 katha 15 lechas, 11 bigha 2 katha 17 lechas were sold to the petitioners. Subsequently, by another registered deed of sale, number 5489, dated 16/9/1985, the remaining 5 bighas 3 katha 18 lechas were sold to the petitioners. The petitioners admittedly did not mutate their names in the record of rights, isn't it? You did not mutate your names after the purchase.
After some time it has come, my lord.
No, you have not. That is why in 2007 you filed that application for mutation. The petitioners did not. Kindly see paragraph 7, paragraph number 7. Show me your name inserted anywhere.
But there is answer 29, my lord.
Huh?
Answer 29, my lord.
Where?
Answer 2, my lord, page 29. Page 29, answer 2.
What does it say?
Bhanagola copy is also there, my lord.
Labdi said, Amrit Ali Sheikh. Then you have
That column, not tenant and father name and address of the viewer.
an
Yeah.
Amin, Ruhul Amin. Then when did your name come?
Series 84, my lord. Why the Rama? नाम जाने की क्या है?
Show me the original of this Jamabandi, Annexure 2. Not that one. The other one. The next one.
There is page 32, but the Xerox copy is there. Original to Swafa Master.
The original.
Original to Master. Original to original. The original Master. Channel is apparently not there, man. Xerox copy.
Hmm?
Original. Original is not there. Original Master. Original Master.
Where is that? Ah, show me that. Your names are not there.
Yes, Saifuddin, yes, this petitioner's names were not. This,
Your names are not there.
not,
You did not mutate your names.
yes.
Just wanted to see as to what is the date of this document. This is also 2007.
Yes, yes, it's 2007.
Admittedly, the petitioners thereupon, after purchase, did not mutate their names. It is, however, claimed by the petitioners had been paying the land revenue. He said as it may, in the year 2007, when the petitioners took steps for mutating their land, their names, the petitioners came to learn that the entire land which were purchased by the petitioner were sold in auction for realization of the area land revenue for the years 1393 BC, 1394 BC, 1395 BC, 1396 BC, and 1397 BC, corresponding to English year 1986-87, 1987-1988, 1998, 98-89, 1988-89, 1989-90, and 1990-91. Immediately thereupon, the petitioner took certified copies of those documents and filed an application before the settlement officer Dhubri and Kokrajhar district on 26/4/2007, praying for cancellation of the auction and deletion of the name of the auction purchaser and restoring the name of the original pataras. What happened to this application?
So far this application is concerned, my lord, nothing has been passed, my lord.
Huh?
Nothing has been passed on that application.
However, no, the, however, the settlement officer, Dhubri and Kokrajhar, did not take any action on the said application. The petitioners thereupon approached the learned Assam Board of Revenue by filing an appeal on 3/10/2007, which was registered and numbered as RA bracket DBR bracket close 160 RA and RA DBR 160 oblique 2007. The records reveal that pursuant to, after hearing both the parties, the learned Assam Board of Revenue, by an order dated judgment dated 13/4/2009, allowed the said appeal, holding inter alia that there was no service of notice as is required under the provisions of the Assam Land and Revenue Regulation 1886 and the rules framed therein under. The sale order dated 14/11/1991 and the sale confirmation order dated 4/4/1992, as well as other relevant orders relating to the sale, were set aside and quashed. The private respondent, the predecessor of the private respondent, filed a writ petition challenging the order dated, judgment dated 13/4/2009 before this court. The said writ petition was registered and numbered as
Page 94.
2250.
Page 94.
Page 94.
WBC number 2250/2009. The coordinate bench of this court by an order dated, by the judgment and order dated 7/3/2013, set aside the order dated, judgment dated 13/4/2009 passed by the learned Assam Board of Revenue. And remanded the matter back to the learned Assam Board of Revenue for a decision afresh. On merits, after taking into consideration, after deciding the issue relating to the delay. Paragraph number 9, 10, 11, 12, 13, 14, being relevant, are reproduced herein under. Footstop. The records further reveal that pursuant thereto, the learned Assam Board of Revenue took up the issue of delay consideration, and by the impugn order dated so and so, It was held that the delay remained unexplained and accordingly dismissed the appeal. It is under such circumstances the present writ petition has been filed. This court have heard the learned counsel appearing on behalf of the petitioner, as well as the learned counsel who appears on behalf of the private respondents. And have also perused the materials on record, including the records of the appeal which was filed before the learned Assam Board of Revenue. This court finds it very pertinent to take note of the contents of the memo of appeal in before the learned Assam Board of Revenue, and more particularly paragraph number 20. There is a specific, wherein it is specifically mentioned some person have filed an application. Some person in the name of Gunaruddin, what is that? Ahmed. Gunaruddin Sheikh had filed an application. Annulment of sale. And the said application was rejected by an order dated 23/3/1994. Paged in the said order, in the said paragraph, that despite the petitioner's endeavor to get a copy of the said application, the said application was not provided. Be that as it may, the certified copy which was obtained by the petitioners on 6/7/2007 was placed before the learned Assam Board of Revenue. For the purpose of adjudicating as to whether the learned Assam Board of Revenue had duly applied its mind while considering the condonation of the delay, this court finds it relevant to reproduce paragraph number 20 of the said memo of appeal. Recorded in the backdrop of the above, if this court now takes note of the impugned order, it is seen that the learned Assam Board of Revenue had come to a categorical opinion that the petitioner had knowledge about the said order, auction sale, in the year 1994 on the basis of the proceedings ordered passed by the learned additional deputy commissioner on 23/3/1994. Adjudication by the learned Assam Board of Revenue as regards the veracity of the allegations so made at paragraph number 20 of the memo of appeal which have been reproduced herein above. It is also very pertinent to take note of that the appeal was filed by the petitioners and not by Gunaruddin Sheikh. It is also very pertinent to mention that the record of rights do not show the name of Gunaruddin Sheikh in respect to the land in question. The record of rights, on the other hand, shows the names of
Gulabdi,
Gulabdi Sheikh,
Gulabdi Sheikh, and Amrit Sheikh, Amrit Ali Sheikh, age 29.
and Muhammad Amrit Ali Sheikh, Muhammad Wahidur Rahman, Muhammad Alam Sheikh, Muhammad Ruhul Amin. This aspect was very much apparent from the record of rights which were enclosed to the memo of appeal, and more particularly Annexure 2 to the memo of appeal. Annexure 1 and Annexure 2 to the memo of appeal. It is therefore the opinion of this court that on the basis of the application, on the basis of the order dated, on the basis of the proceedings dated, proceedings initiated by one Gunaruddin Sheikh Supra, by one Gunaruddin Sheikh, application was rejected thereupon by the order dated 23/3/1994 by the Additional Deputy Commissioner, not have been taken into account by the learned Assam Board of Revenue in deciding the application for condonation of delay. It is well settled that when a discretion has been granted to the respondent, to an authority to exercise, discretion has to be exercised in a reasonable and a pragmatic manner. The non-exercise of the discretion in the manner provided under law, in a reasonable or a pragmatic manner, renders the exercise of discretion coming within the ambit of malice in law. Taking into account the above, it is therefore the opinion of this court that the impugned order dated 6/2/2014 passed in case number 160 RA (DBR) oblique 2007, which is impugned in the instant proceeding, cannot be sustained in law. Accordingly, the instant writ petition stands disposed of with the following observations and directions. Number 1, the impugned order dated 6/2/2014 passed in case number 160 RA (DBR oblique 2007 is set aside and quashed. Number 2, the learned Assam Board of Revenue is directed to decide on the question of limitation, a question of delay. In approaching the learned Assam Board of Revenue in the year 2007 in respect to an auction sale which was conducted in the year 1991 and a sale being confirmed in the year 1992. In doing so, the learned Assam Board of Revenue shall also take note of the revision jurisdiction, the supervisory jurisdiction under Section 151 of the Assam Land and Revenue Regulation 1886. And the settled principles of law that while exercising the jurisdiction under Section 151 of the regulation, there is no period of limitation. Next. The records be returned back. Both the parties being present before this court, they are directed to appear before the learned Assam Board of Revenue on 14th of September 2026. Registry shall forthwith return the records to the learned Assam Board of Revenue so that in compliance to the directions passed herein above, the learned Assam Board of Revenue shall consider the aspect pertaining to delay, and thereupon, if the delay aspect is decided, the appeal is thereupon taken up on merits.
Deeply obliged, my lord.
Find out judgments. He has referred to one judgment of 1952, and that judgment swayed with the court. So you need to find those judgments of 65, and this court is now going.
This matter relates to allotment of your lordship, LPG distributorship, your lordship. An advertisement was issued, your lordship. Advertisement was issued, which is at page 16, your lordship will find at serial number, this is an extract translated, serial number 63 and 64. We are concerned with 64, Namru, Nahorni block, open category, and your lordship will, this is the crucial Rarban, your lordship, category. Now, what is Rarban, your lordship? I apply that your lordship will kindly come to page 23. This is the brochure of the issued by the Indian Oil. Page 23, your lordship will find type of distribution, a distributorship area, Sahari Bitrak. In this document, the word urban area, your lordship will kindly note that. We'll have the definition of urban as per census 2011. LBG distributorship located in urban area will serve this so and so. Then second one is urban Bitarak, your lordship. It says in this document, the word rural urban means LPG distributorship located in urban area and also providing the service in the LPG customers in specified rural areas, generally covering villages falling within 15 kilometers from municipal limits of the LPG distributorship location and on the area specified by the respective OMCs.
Rarban.
Rarban.
Or urban?
Rural and urban, your lords. It is will be in the urban area, but it will cater to the need of rural area, your lords. Now, urban, they have said will have the same definition of urban as per census 2011.
Where is that?
That I will show your lordship. Now, if your lordship sees that below D, E, and F, more particularly EF, they have defined what is metro city, what is city, and what is town.
Going to page.
Page 23, your lords. Is the Sahari Bitrak, that is, there your lordship will find the urban area definition. Urban Bitrak, we are concerned with this, and it will be located in the urban area. Then Gramin Bitarak and Durgam Khetra, then they have defined metro city, city, town, village, etc. Your lordship. Now I applied, your lordship, pursuant to this, and in the lottery I got selected, your lordship, and accordingly, your lordship will find at page 86, your lordship, 85, your lordship. There is a certificate issued by the circle officer regarding the place which I have offered, your lordship. Page 85.
When did you submit the application?
That, your lordship, I have submitted the application. It was published on 12/6/2018. He submitted his application on 25/7/2018. Para 4 of my writ petition, your lordship, I have mentioned.
No, you submitted on 13/7/2018.
Page 20. Thirteen seven 2020.
18.
On 25/7/18, there is an online computerized draw of lots where I got selected, your lords. 25/7/2018. Now, your
they
lordship,
say
now
that
they
your land is outside, page 92.
92, your lords. They say the plot of land offered for construction of showroom is not within the town limits, your lords. Your lordship will kindly note that, your lords. Now, town and urban area has two different meaning, your lordship, as per their own brochure, your lordship. Now, your lordship will kindly come to page 85. That is the circle officer certificate which I have submitted to them.
What do you say about Annexa P5?
Lordship,
P5. The affidavit.
lordship.
This is the circle officer's report.
That I have, that is by the
Circle officer.
affidavit to go to. এখন interlocutor.
This document is contrary to the document at page 85.
Lords. This is your lordship, same document, your lordship.
No, this is the contrary document to page.
Lordship,
85.
which reference the subject, I would like to inform you that the plot of land covered by so and so situated Nagamati Crematoria Gaon under Joypur is recorded in the name of so and so. Records under the said plot of land does not form exist in Namrup Town Committee. That is accepted, your lords. It
No,
is the
please kindly see page 85.
lordship. 85 says your lordship will find this is to certify that a plot of land covered by so and so is recorded in the name of so and so as per records under Naharkoti Revenue Circle. The said plot of falls under the demarcation area noun committee according to the master plan, your lordship. That is what is the
Here it categorically, however, the villages in which the said plot of land is situated has been earmarked under demarcation area of so and so. Yeah.
now your
But
lordship.
as on the date on which the notification was issued, it did not fall within the town committee.
It does not fall, your lordship. There's an admitted position, your lordship. Now, your lordship will kindly see this certificate is issued on the basis of report of chairperson, Namrup Town Committee report. Now, your lordship will find that there are two reports by the Namrup Town Committee. One, your lordship will find, this is on the basis of their page 90, your lordship. This was submitted to the IOCL authorities, your lordship, by
Right.
the town committee. It says with
This is
reference to the,
subsequently.
this is subsequent. With reference to this above cited, we are pleased to inform you that the plot of land offered for construction of LPG showroom and go down bearing DUG number so and so owner so and so is not within the demarcation of the Namrup Town Committee. Then your lordship will come to page 91, another letter by the town committee chairman. Due to lack of proper verification, we have already informed you by letter number so and so that the plot of land offered for construction of LPG showroom and go down bearing that number so and so is not within the demarcation of Namrup Town Committee, but as per final master plan of the Namrup 2025 prepared by the Town and Country Planning Government of Assam, dispute the above mentioned revenue areas included in the master plan of Namrup. Now, your lordship, that is my case lies on that only, your lordship.
No, it cannot because of the fact that there has to be a notification as per the Town and Country Planning Act to bring within the ambit this thing. Where is that notification? If you have that notification, matter is over.
Your lordship will kindly see.
That is the only case.
Yes, that is what I am trying to show.
So for that you require the notification.
Yes, that I will show your lordship. That's there is a gazette notification. Your lordship will find page 50. Notice for publication of the final master plan, your lords. Page 50, it starts. In exercise of power conferred by subsection 1 and 2 of section 10 of Assam Town and Country Planning 1959, read with so along with rule 2 of Assam Town and Country Planning publication of master plan amendment.
And this is proposed. Where is the
Lordship.
notification under the Town and Country Planning Act?
Now, this was by the Town and Country Planning, your lordship
No,
authority.
no, there has to be a notification as per that. This is a proposal. Now the question is, where is the notification? The Town and Country Planning Act on this. Town and Country Planning. এখন আপোনাৰ ইয়াত পাব এই মিউনিচিপালিটি লগত থাকে আসাম টাউন এণ্ড
Your lordship will find that in the certificate itself, they have talked about this final master plan.
says that it will be brought within the master plan.
Lordship,
Has it been brought as of
That-
the date
that-
on which?
from what they have stated in page 91, your lordship,
No, there
but
has to be
as per the final master plan, your lordship will can.
that final master plan, it will be brought in by way of a notification.
Notification,
Where's
Your
the
Lord.
notification?
No, that I have not annexed,
So,
your lordship,
yeah,
but
the-
otherwise, your lordship, they,
11, my lord.
Huh?
Page 11. The affidavit, my lord, filed by the IOC, my lord,
111, yes. No, that is what,
as on date of the last date of the advertisement,
Hmm.
13/7/2018, my lord. It was
now
not.
the
within-
village in which the said plot of land is situated has been earmarked under the demarcation area of so-and-so according to the master plan report and published in the year. Yes, it is earmarked, but there has to
Yes,
be
yes, ma'am.
notification to that effect. So, yes,
according to them, your lordship, this falls, and your lordship, if your lordship.
it
still-
does not fall unless there is that notification
No,
under the Assam Town. and
Town
Country.
committee says, your lordship, that it final master, as per final master plan.
It cannot be, there has to be a notification. to
No,
the-
that's there, your lordship, unless that is there, your lordship.
Mr. Watako, that won't help you. Unless you bring before this court that notification to that effect, which you have failed after a period of 8 years.
In fact, your lordship, problem is this, your lordship. I don't have any contact with my client, that's the problem, your
He
lordship.
has
I
also
could not
lost
even file a reply, your lordship, because of that,
hope on this.
lordship, that may be. But your lordship, ultimately, your lordship, as per their town committee's
No, not
later,
that.
your lordship, the final master plan has been published, and your lordship, we fall within that, your lordship.
Pre-planning act. Now works.
That act is there, your lordship. I have brought that.
Adha ways.
And in fact, your lordship, if you, your lordship can take my book, your lordship.
I had specifically taken up one matter of Mr. P. Mohanto on Tejpur as to whether a particular area, there has to be a notification.
Yes, your lordship, a final, first the draft proposed and then a final
There's a final notification.
final
which is-
notification. Method marks আপনি আছে নাকি? Final notification of master plan for number of town common. Final notification for master plan. কেতিয়া? এখন কেতিয়া? ডেটটো কেতিয়া?
19 of
25 আমি। এখন আৰু নাই নেকি? Your Lordship will kindly see the second paragraph of this notification, Your Lordship. Second paragraph, Your Lordship may, of the Gazette notification, Your Lordship may kindly see. Clause serial number 3, it is notified that final master plan for Namrup prepared by the Director, Town and Country Planning Government of Assam and adopted by the state government under section 10(2) of Assam Town Country Planning Act 1959 reviewed so and so for the areas described in the schedule below is hereby published.
Where?
Second, your third column, Your Lordship, page 53rd, serial number 3.
Master plan.
Final master plan has been adopted, Your Lordship. Here, Your Lordship, it has been, objection has been not called for, Your Lordship. It is the final, Your Lordship. And page 80, Your Lordship, may last Constitution of Development Authority. And in census 2011, Your Lordship, এইটো দি দিয়কচোন। According to them, it will go by the 2011. Now, your lordship, my case is this, your lordship. While rejecting my application, your lordship, they considered the fact that I don't fall within the within the town area, your lordship, municipal town, your lordship. Now, they ought to have considered whether I fall within the urban area or not, within the meaning of the definition of urban area given in census of 2011, your lordship. Because according to their own brochure, it is the 2011 urban area will be, the definition of urban area will be taken as per the definition given in census of 2011. The consideration itself is wrong. If they have find out and they have arrived at a finding that I don't fall within the urban area, therefore I have been rejected, then matter would have been different, your lordship. That aspect they have not gone into, your lordship.
Now, Mr. Botaku, you
Lordship.
have the copy of the act?
No, your lordship, I have given that to your lordship book. In network finding. I will go through, your lordship, in the
Section 10
lordship.
stipulates the mandate, how it is to be done.
Lordship.
Meaning there, first the director will prepare it, then it will go to the government will adopt it, and then it will be sent for people to know.
Lordship.
Section 11 is relevant for a purpose as to say as to what would be the contents of the
Lordship.
year. Then the last section out there in that page itself,
Lordship. 12.
12, says that once it is being done, it will be sent to the authority under 8A,
Lordship.
meaning thereby an authority will be constituted by a notification to be the town committee.
Lordship.
Now kindly see 13, which is relevant, the
Yes.
next page. Now with the publication of EA, there cannot be any sale or EA without the permission of the authority. Meaning thereby, with this notification of 2010, it would come within the ambit of the authority.
Lordship. 13, your lordship. The plan as adopted by the state government shall be published as prescribed in section 10, and after such publication, no person shall use any land, subdivide any land by transfer by way of gift, sale, partition, or any other manner, whole or any part of the land, or set up any new structure on any land covered by the or change the existing structure of any building or use of any building or land within the area except with the permission of the authority.
That means it is the moment it is being published in the manner in terms with section 10,
Lordship.
it would become implementable as per section 12.
Lordship.
The moment it is sent to the section 12,
Lordship.
implementable, and once it is implemented, the authority comes with it. So therefore, on the publication of this notification dated 19/10/2010, it is already brought within that revenue circle has been brought within the NAM. This is the they may write various letters, but it seems to be the logical. Have a look at this paragraph. See the sections, not these, not that book. Only see section 10.
10.
10, 11, 12, and 13.
Your lordship may kindly see the definition of urban area in 2011 census, your lordship. That I have,
What is this?
urban area, it does not say, your lordship. Urban agglomeration, your lordship. An urban agglomeration is a continuous urban spread constituting a town and its adjoining outgrowths, your lordship. Therefore, they should have looked into from that angle, your lordship, whether we will come within that or not.
No, therefore, once it is comes under the
Lordship.
Assam Town Committee,
Then
the
it will
town
be an urban.
committee, not within the town limits, it cannot be said so, because as on 2010,
Lordship.
it comes within it.
My
Because
lord,
the authority otherwise would not have jurisdiction unless it is implemented.
true, my lord. Your lordship
Now,
is very
it
good.
gets implemented the moment the government approves it, the final master plan.
My lord.
From a perusal of page 50 of the writ petition, it is seen that the final master plan have been approved and adopted by the state government under 10.2.
Yes, my lord.
Thereupon, the publication is been made for the purpose of persons' information to the people.
My lord.
Prior to that, the objections will come in. If you see 10.1,
10.2,
the
10.2.
objections are there as per 10.1.
Yes, my lord.
So therefore, the moment this particular document came in, it came within the ambit of this particular revenue circle.
Right.
Kindly see page 51. Nagar, what is that name? You have done it in such a manner nobody understands.
Lordship, page 51, serial number 5, your lordship.
You can read it.
My lord. Gauhati area government.
Gauhati
Area
Area government.
government.
So this very revenue circle comes within the ambit of the town, Namrup town. There. And therefore, the use is revenue areas included in the master plan,
True.
brought within the ambit of the master plan.
Yes, my lord. Now, my lord has stated this from page 51 that the towns and villages would be bought under the master plan. Now, my lord will kindly come to page 54, my lord.
Okay.
Page 54.
Yes.
Your lordship sees Namrup master plan area. Then, my lord, for planning purposes, Namrup master plan area has been divided into the following zones. The urban zone in A, and at page 55, the rural zone, which includes the village, the land, plot of land offered by the petitioner, my lord, at serial number 7. So, as I understand from this, my lord, is that the nature of the rural zone has not sought to be changed. The government, in its wisdom, my lord, decided to upgrade and make the entire area of Namrup into a smart livable area, my lord, without the essence of the rural areas losing that aspect of rurality, my lord. This is what 55 tells me, my lord. Then my lord will kindly come to page 79, my lord. Page 79.
Yes.
Page 79, my lord. Your lordship sees zoning regulations, my lord. Then, my lord, plan implementation. The plan implementation, the second, my lord. Preparation of the master plan and zoning plan for Namrup and its mere adoption by the government is not the end of the planning process.
in order to make the town a better place to live and work, sustained efforts to enforce and implement the master plan proposals are necessary. So this is at the beginning of a chain of events that the government had to ensure to bring, if at all, my lord, Nogamati Kheremia Gaon into the urban township, my lord. What has happened thereafter, my lord, I understand that the state will have to answer, but as per page 111, my humble submission, my lord, Nagamati Kheremia Gaon does not qualify as an urban area, my lord. And my lord, the impugned order which has been appended in the writ petition is of the month of February 2018. In our affidavit, my lord, we have appended a later communication, my lord, which your lordship has gone through, 111, my lord, which is 5th of September 2018. It's from the government, my lord, that it does not fall within the demarcation area of Namrup Town Committee. Now, reading this letter with the language of the master plan, I understand, my lord, in my humble submission, that the master plan would include zoning and allocation of two segments of areas, both urban and rural, notwithstanding the provisions of the act. The nature of the land in Nagamati Kheremia Gaon is not sought to be changed. It has sought to be made better and smarter. Two zones, urban zones and the rural zone at page 54. That nature has not sought to be changed in the master plan, my lord. The rurality of that area stays. And if your lordship can kindly come to page 83, my lord, page 83. Page 83.
Yes.
This is a map, my lord, near the area where Delhi would be situated, my lord. There's is Nagamati Kheremia Gaon. Your lordship sees that? Topmost, my lord, near Delhi, Punjab, my lord, that area, my lord. It's a photocopy I have, my lord. And the legend here says,
Which portion in your
my
thing?
lord, my lord, the northwestern, this portion, this is the village, my lord. This is the area, my lord.
Abjan tea state.
Not Habjan Tea State, my lord. It is on the left of Habjan Tea State, my lord. That is Nogamati Kheremia, my lord. Your lordship sees that is for small photocopied letters on my petition, my lord. The legend there, if your lordship sees the legend in the legend place, my lord, it means it's paddy field. But that is not disputing the fact that it cannot be urbanized. But looking in the language of the master plan, the area falls in the rural zone, my lord. It's paddy field, my lord. The legend, my lord. Industry. Oh.
Now explain to me, Mr. Sharma, what
Hello.
is this rural?
My lord. Yes.
You say out here,
My lord.
rural.
My lord. Urban.
You see, marketing type LPG distributorship, rural, oblique Gramin,
My lord.
oblique interior. So, Gramin means what?
Village, my lord.
Village. And what is interior?
Interiors of a village, my lord. Village interiors, my lord.
Huh?
Village interiors is a broader term, my lord. It can
No,
be
no, all are given with an oblique. Let's see in Assamese what they have given. You need a magnifying glass for that. Can't read it. What they mention? These three? Page 7. Did it?
Page 70, my lord.
17?
17.
For you also difficult, no? So Botagur can read it?
Lordship, this is an advertisement, your lordship.
Understood. What is written on top?
Here, your lordship, so far as that part is concerned, it is only in the brochure, your lordship.
You see, you see the particular marketing types of
Lordship.
LPG distributor, Ruben,
Lordship, that your lordship,
Ramin
it is,
interior area. What is the terms used here
He-
in Assamese?
here it Namrup, Naharani Khandra, Dibrugarh, open, rural, urban Bitorok. They have used the word urban Bitorok. Urban. They have not. Marketor processor LPG Bitorok, Urban, Gramin.
And what is this block?
Block means in which block it is?
No, it says Naharani block.
Revenue block, your lordship.
Yes. What is your land? Why the terminology block has been mentioned? Naharani block means what? They have also referred to the Gaon Panchayat. So if they are mentioning as Gaon Panchayat to Namru, before Gaon Panchayat, if they are mentioning, there cannot be a Gaon Panchayat in
Urban.
Town.
town.
My lord will kindly come to page 38. Page 38. Page 38, my lord. The clause is 15, my lord. Draw of lots.
Mm.
Lordship sees that.
Yes.
My lord, then your lordship would see a sub clause inter se priority draw for Durgam Hetrio Vitrok, my lord. Then the last paragraph before the other sub clause. For Seheri Vitrok, Rarban Vitrok, Ramin.
For Seheri, Ruban, Vitrok, so and so, the inter se priority based on residence of the candidate in the concerned
Will
Gaon
not be
Panchayat
applicable.
or concerned revenue division will not be applicable.
Inter se priority. That means, your lordship, based on that, it will not, priority will not be given. That is, your lordship,
This is a residence.
residence, your lordship.
How is
On the basis of residence, we cannot claim priority. That is what it is stated, your lordship. It has nothing to do with that, your lordship.
Kindly see, eligible applicants residing in the concerned Gaon Panchayat.
Of
So
the
there is a
advertised
priority.
location.
The drop lot, there is a priority be given.
In respect of Durgam Kshatriya Bitarak locations, your lordship. Only in respect of that
No,
priority will be
so,
given.
but that is besides the point. My question is, if you are taking out everybody, then why you mention about the Gaon Panchayat?
Gaon Panchayat.
The reason I attribute that, my lord, to the boilerplate format which is used for the advertisement. Because, my lord, otherwise, in this matter, my lord, the eligibility has been clearly.
Just for example, at number 60 and 61, you have not mentioned anything.
Yes, blank.
Right. And what is this type of very difficult to read it. Mr. Botakur, what is 60 and 61?
60 is, your lordship, this is Zir coming. Here, your lordship, it is from Hamren.
What type of is this?
This is, your lordship, Durgam Kshatriya.
Durgaon Kshatriya means?
Durgam, it's interior, your lords, interior place.
Interior, there is no Gaon.
No, it's Durgam Khetriya Vitrak LPG distributorships in difficult and special areas.
No, this is because your lordship in these two places, probably panchayat is not existed, your lordship. Hamra,
Therefore, there is a, can you see number 35? This also.
this is also your lordship in Karbi Anglong. Etu ham.
These are all Karbi Anglong.
Karbi Anglong.
So therefore, they have been very attentive where there is no Gaon Panchayat, they have not mentioned. Then is it only for the purpose of residence?
That what I'll understand, my lord. That is what I'll probably refer, because my submission is that the entire process of selection has to proceed from the definition which has been postulated in paragraph page 23.
Now, if we see Namrup,
My lord.
then
Panchayat is Namrup.
Hondo is Nahoroni. Then the Zilla is Dibrugarh. And then Srini is what? Open.
Now your lordship will kindly come to last, your lordship. Gauhati, Kalapahar. Here it's very clear. Municipality. Last one.
Ah.
It's purely urban. Therefore, your lordship, here they have mentioned the Gauhati municipality, your lordship. Very specific.
If you have not put the town committee,
Lords.
can you therefore say so?
No, because my lord, the invitation to offer by way of this advertisement is dependent on the aspect of the petitioner applying under the urban category. Now, assuming my
Let
lord,
us see the definition of urban.
my lord, page 23, my lord. Page 23.
This document, the word rural urban means LPG located in urban area.
Yes, my lord. And also providing service.
In the LPG. Rural area. Villages falling within 50 kilometers from the municipal limits of the. Or the
Now your
area
lordship,
specified
urban
in
area,
the OMC's LPG distributor servicing the area will be called the urban. Okay, so therefore, one is Seheri. Seheri is town.
My
town,
lord.
complete.
Urban is, it is urban,
Urban.
Urban,
but catering to rural.
urban and rural. 15 kilometers within the
Now,
limit of, yes, my lord.
Your lordship will find
Amin is rural.
Rural, my lord. And Durgam Khetriya Vitrak, my lord, is for
Difficult and special area.
my lord,
Lords.
my lord.
now just above that, your lordship will find the word urban area will have the definition of urban as per census 2011. Your lordship.
Where?
Just top, your lords.
Ah.
Tehri Bitorok.
Census 2000.
Really?
Yes.
Now that's what I have.
So therefore, you say on the basis of this,
This we will have to see, read this along with census of India 2011. Your lords. Urban agglomeration. Towns, there are specific definition. Then urban agglomeration. An urban agglomeration is a continuous urban spread constituting a town and its adjoining outgrowth, or two or more physically contiguous towns together or without outgrowths of such towns.
that is understand, but what have they defined? Is this the only document out there? This is provisional town area.
So that is what I have.
Urban agglomeration and cities. But does it, the census of 2011 look into specifically mention about, because here it says urban will have the definition of urban as census here. So
Look.
can we take urban to be the urban agglomeration.
No, I don't find anything more than that in this census 2011.
You
I will
look
have
into
to,
it.
Lordship.
We'll take it up. I have another matter, some division bench. I don't know how long it is taken. After that, we'll look into it. In the meantime, you look into this. You'll get it in the internet.
My lord.
Did you find out? What does it say?
I have gotten three documents, my lord. The first is a communication from, my lord, the Office of the Registrar General India, my lord, 4/9/2018. There, my lord, point number 2, first page. Point number 2, first page, my lord. The second paragraph, the first step in this direction has already been commenced by preparing an updated list of villages and towns after incorporating the jurisdictional changes that have taken place after census 2011 and up to 31/12/2017. The next step is to identify the census towns by applying the urban criteria to all villages, including the census towns and outgrowths of census 2011. The definition of an urban unit at the 2011 census was as follows. All administrative units that have been defined by statute as urban, like municipal corporation, municipality, cantonment board, notified town area committee, town panchayat, nagarpalika, etc., are known as statutory town. Further, statutory towns with population of 1 lakh and above are categorized as cities. My lord, it's proven that Nagamati Kheremia Gaon is not within Part A. Nagamati Kheremia Gaon will not fall under the categorization at 2A. It will come under 2B. If at all it does come, my lord. All other places which satisfy the following criteria: a minimum population of 5,000 persons, 75% and above the male main working population being engaged in non-agricultural pursuits, and a density population of at least 400 persons per square kilometer. If at all, my lord, it has to qualify as an urban unit. The definition which was used in the 2011 census, my lord. It is proposed to retain the same definition for urban areas, my lord, if your lordship has seen. This is the population, my lord, which has been relied on by my senior friend, my lord, as well as at the IOCL.
But there has to be a minimum population of 5,000.
Yes, now my lord will come to the second printout.
Area means it has to be all. There is no or.
There is no or. And conjunctive, my lord. Now my lord will kindly come to the second printout, my lord. The Namrup town population census 2011 to 26. My lord sees that. The population of Namrup, my lord, is a census town city in district of Dibrugarh, Assam. The population is 15,719. Now this fulfills the criteria, but again, my lord, it is for the town committee and a jurisdictional purview therein. Then, my lord, the third printout. The third printout, my lord. Nagamati Kheremia Gaon population. It's a population of, my lord, 1,686.
Is the document from where did you get this?
My lord, this is from the census, my lord, the same source, my lord, as the second printout.
Where?
It's a government source, my lord. Namrup census city town population census 2011-2026, my lord. And the third, my lord, the same source, but somehow, my lord, the source is not indicated, my lord.
On top it is given, na?
It is given, but yes, my lord.
Top
The census, that census.
Karmati Kherema Gaon village population.
Yes.
Population census.
So
I mean to say that this will not fall in view.
based on the information here, my lord, that because the brochure is clear, the urban aspect has been completely different from town and cities, my lord, at page 23. So that demarcation has been given by the IUCL. So I cannot rely now on the fact saying that it's not a town or a city, because that is not my case. My case is whether Nagamati Kheremia Gaon would be an urban area. Now, the town committee and the area that comes under the town committee, that population is 16,000. Nagamati Kheremia Gaon would not come under that, because it is excluding the town committee jurisdiction, my lord, and the population is 1,600. And the census
And these are conjunctive.
conjunctive, my lord, not disjunctive, conjunctive. There's no aspect of or.
Yes, Mr. Counsel.
Port number 4.
What?
Port number 4, man. Yes. So
We dictate.
after some time, after some time.
Huh?
After
No,
some time.
no. I have to dictate and then do the next. Heard Mr. S. Bottakur, the learned senior counsel, assisted by
Digo.
D. Gogoi, the learned counsel, appearing on behalf of the petitioner. Mr. M. Sharma appears on behalf of the respondent numbers 1 and 2.
1 and 2, my lord.
And appears on behalf of the respondent number 3 and 4. The present petition has been filed challenging the communication dated 29/9/2018 the petitioner's application for award of LPG distributorship at Namrup District, Dibrugarh,
My lord.
under the open category advertised on 12/6/2018. In the type of LPG distributorship, that's Ruban, RURBAN, was rejected, and the amount of rupees 50,000 was stood forfeited
My lord.
in line with the terms and conditions of the advertisement. Next, brief facts of the case. On 12/6/2018, a newspaper advertisement was published in the local daily Ohomia Proceedings for appointment of LPG distributors under the Indian Oil Corporation Limited, Bharat Oil Corporation Limited, and Hindustan Petroleum Corporation Limited. In the said advertisement dated 12/6/2018, the LPG distributorships were offered for 3 types of markets, that is, Rural, Gramin, interior area. Who had it's a lease property.
My lord.
We had taken a lease. Where's the lease deed?
The lease deed has not been appended, my lord.
Not next.
Page 85 would be the details of it, my lord.
We had taken a lease of a plot of land covered by DAG number 340 or PP number 16, at measuring an area of now with the dimension of 30 into 25. Situated at Nagamati Kheremia Gaon, Namrup Road, Naharkotiya. in the district of Dibrugarh, Assam, had applied for the LPG distributorship under the rural type category under the IOCL for Namrup area, Naharoni block, under the open category. Said application was submitted by the petitioner on
13/7, my lord.
13/7/2018. Full stop. In the draw of lots, which was conducted on 25/7/2018, the petitioner was selected for the Namrup area. Full stop. Petitioner was duly informed about the said aspect about the petitioner was duly informed about the outcome of the draw of lots and that the petitioner was provisionally selected. The petitioner was asked to deposit the security deposit of rupees 50,000, which the petitioner did by submitting a demand draft on 4/8/2018. To the on 29/9/2018, the petitioner received an email from the DGM bracket LPZ-L S bracket close IOCL informing the petitioner that his candidature for the LPG distributorship at Namrup under the open category was rejected as the plot of land offered for construction of the showroom is not within the town limits of the advertised location of Namrup as on the last date of submission of the application, that is 13/7/2018. Being aggrieved by the said email, petitioner had approached this court by filing the present writ petition. It may not be out of place to mention in the meantime, draw of lots held on 11/10/2018. Another applicant, namely one Mr. Jagat Nayak, was provisionally selected.
My lord, the draw plots hadn't yet taken place, my lord. The stay was on 9/10. 11/10 was a scheduled date.
On what the petitioner has obtained a printout of an email issued to one of the applicant.
my lord. The stay was granted, my lord. There is a stay operating in this. my
Okay.
lord. 9/10/2018. But there was a stay on this.
Nalage, had approached this court by filing the writ petition. The record reveals that by an order dated 9/10/2018, coordinate bench of this court, by an order issued notice and further directed that the status quo as on 9/10/2018 as regards award of the LPG distributorship at Namrup under the open category shall be maintained. Same order thereupon have been extended from time to time. It is further pertinent to take note of that an affidavit in opposition has been filed by the respondent numbers 1 and 2. Wherein it is the stand taken that as per the land documents so submitted by the petitioner, the land was covered under DAG number 340 and Patta number 16 of Nagamati Kheremia Gao. A clarification regarding the ownership of the land was sought from the Namrup Town Committee by the communication dated 24/8/2018 with the subject regarding whether the land offered for the showroom is within the boundary of the Namrup town area. It was further mentioned that on 27/8/2018, a letter was received from the chairperson and the executive officer Namrup Town Committee
Page 90, my lord.
wherein it was informed what did it inform?
That that plot of land is not within the demarcation of Namrup Town Committee. That goes against their own statement at page 85.
Where is that document?
At page 85, my lord. 85 and 90, my lord. 90 is where on 27/8 they stated that it is not within the demarcation of the town committee. And page 85 is where they have made a slightly different take, my lord. 85 and 90, my lord. Two different stands, my lord. One is by the circle officer, the other is by the Namrup
Wherein
town.
it was informed that a plot of land offered for construction of the LPG showroom and godown is not within the demarcation of the Namrup Town Committee.
My lord.
Upon receipt of the said communication dated 27/8/2018, the IOCL authorities on the same date issued a communication to the petitioner requesting to provide an alternative plot of land for construction of the showroom, which was duly received by the petitioner. It was further mentioned that on 30/8/2018, the IOCL authorities for the ends of justice issued another letter to the petitioner in the same context. However, the petitioner did not provide any alternative plot. Respondents number 1 and 2 also averred in the affidavit that a clarification was sought from the circle officer Naharkotia by the communication dated 4/9/2018 as to whether the land falls within the urban area. In reply, the circle officer Naharkotia, by the letter dated 5/9/2018, confirmed that the said plot of land does not fall under the existing demarcation area of Namrup Town Committee as on 13/7/2018. Full stop. Respondents further in the affidavit have relied upon the Unified Guidelines for Selection of LPG Distributorship of October 2017 and the definitions contained therein. The records further reveal that the petitioner have filed an affidavit in reply indicating and reaffirming the statements made in the writ petition. In the backdrop of the above, let this court take note of the respective submissions so made by the learned counsels appearing on behalf of the parties. Mr. S. Potagu, the learned senior counsel, referring to the advertisement dated 12/6/2018, submitted that the type of LPG distributorship in respect of which the petitioner applied is Rurban, Rurban. Referring to the Unified Guidelines for Selection of the LPG Distributors, which is Annexure 3 to the writ petition, the learned senior counsel referred to
Page 23, my lord. Sahari Vitrok, my
the definition
Ma'am.
of the types of distributorship area. The learned senior counsel submitted that in terms with the definition of the term Rurban Vitrak, the LPG distributorship is required to be located in the urban area wherein and thereby providing service to the LPG customers in specified rural areas, generally covering all villages falling within 15 kilometers from the municipal limits of the LPG distributorship location. The learned counsel, senior counsel submitted that the urban area have been defined to mean the same definition of urban area as per the census 2011. In that regard, he had referred to the term urban agglomeration, which is mentioned in the census of India 2011 to be a continuous urban spread constituting a town and its adjoining growths, two or more physically contiguous towns together with or without outgrowths of such towns. The learned senior counsel further submitted, drawing the attention of this court to the master plan, final master plan, which have been adopted by the government, state government, and notified by notification dated 19/10/2010, and submitted that the Nagomati Gaon have been brought within the master plan of Namrup for Namrup. The learned senior counsel further drew the attention of this court to the communication to the certificate issued by the circle officer dated 1st of September 2018, wherein it is mentioned that the plot of land falls under the demarcation area of Namrup Town Committee according to the master plan report prepared by Town and Country Planning Department, Government of Assam. The learned senior counsel further submitted that though the respondents have relied upon the communication dated 27/8/2018, but subsequently the office of the Namrup Town Committee, by the communication dated 30/8/2018, have specifically mentioned as per the final master plan for Namrup 2025 prepared by the Town and Country Planning Government of Assam Dispur, the covered by DAG number 340 of Patra number 16, situated at Nogamati Kheremia Gaon, is included in the master plan for Namrup. From Mr. M. Sharma, the learned counsel appearing on behalf of the respondent number 1 and 2 submitted that though in the final master plan, which was notified by the notification dated 19/10/2010, Gamati Kheremia Gaon is brought within the ambit of the master plan of Namrup, but the said area, said village have been maintained as a rural area, and in that regard referred to
Page 54, my lord. Namrup Master Plan area, page 54, 55.
the master plan, the final master plan, wherein under the heading Namrup Master Plan Area, all caps, the area have been divided into two zones. The urban zone comprised of areas which fell within the township of BVFC, APL and ACB, and urbanized areas adjacent to those townships. However, the rural area comprised of various villages, including the Nagamati Kheremia Gaon. The learned counsel appearing on behalf of the respondent number 1 and 2 therefore submitted that even in the final master plan, the said area have been treated to be a rural zone. The learned counsel further
That picture, my lord.
referred to the portion under the heading Plan Implementation and Enforcement, and more particularly with the heading, inverted comma, Plan Implementation. and submitted that from the very reading of that very reading and submitted that from a reading of the content of the plan implementation, it would show that the development schemes would be applied in a phase-wise manner. And therefore, the Learned Counsel submitted that as on the date of issuance of the final notification, the issuance of the final notification of the master plan, the Nagamati Kheremia gown continued to remain or treated as a rural zone. The Learned Counsel further, referring to the map, master plan of the master plan, also the map of the map enclosed to the master plan also submitted that the area wherein the Nagamati Kheremia gown is situated have been shown as paddy field. In the backdrop of the said master plan, the Learned Counsel for the respondent number 1 and 2 therefore submitted that it is in that context the respondents, that is the respondent number 3 and 4, have categorically mentioned that though the Nagamati Kheremia gown have been brought within the master plan, but the same was yet to be brought within the Namrup Town Committee. The Learned Counsel further, referring to the definitions of Sehari Vitrak, Rurban Vitrak, Gramin Vitrak, and Durgam Kshetriya Vitrak, as defined in clause 1 of the guidelines, submitted that to be a Rurban Vitrak, the area wherein the LPG distributor has to be located is an urban area. The urban area has to be recognized from the definition of urban as per census 2011. The Council further submitted that from the notification dated 9/9/2018.
My lord, it might be 4/9. It seems 9, but I think
4/9.
4/9.
4/9.
Because the 2 9s are different or 2 4s are different, my lord. It cannot be 1. 4/9 seems.
From the notification, from the communication dated 4/9/2018 issued by the Office of the Registrar General India in relation to the census of India 2021, circular number 2, the definition of urban have been explained. Urban area as per census 2011 have been duly explained. He submits that the urban unit at the 2011 census would include all administrative units that have been defined by the statute as urban, like municipal corporation, municipality, cantonment board, notified town committee, town panchayat, nagarpalika, etc., are known as statutory town. Further, statutory towns with population of 1 lakh and above are categorized as cities. The Learned Council further submitted that, that urban areas would also, the definition of urban area also would include those places which satisfy the criteria of Roman 1, a minimum population of 5,000 persons, Roman 2, 75% of the above of the male main working population being engaged in non-agricultural pursuits, semicolon, and Roman 3, a density population of at least 400 persons per square kilometer, bracket rupee 1,000 per square mile. The Learned Council further submitted from the document which have been taken out from the
My lord, the website of the Home Department of Assam, my lord.
website of the Home Department of the State of Assam
My lord.
in connection with the census 2026.
2011 to 26.
2011 to 2026, that the Namrup town population census that Namrup is a census town city in the district of Dibrugarh
My lord, Dibrugarh, my lord.
and has a population of 15,719, of which 8,187 are male, while 7,532 are female, as per the report released by the Census India 2011. The Learned Council further submitted that insofar as Nagamati Kheremia Gaon population is concerned, as per population census 2011, the population is 1686, of which 847 are male, while 839 are female. On the basis thereof, the Learned Council therefore submitted that as the location in which the petitioner had submitted the land, offered the land, do not come within the definition of Rurban, Vitrak, the respondents were therefore justified in rejecting the petitioner's application and forfeiting the security deposit of rupees 50,000 as per the terms and conditions of the contract of the guidelines. Full stop. Analysis and determination. This court have duly heard the learned counsels appearing on behalf of the parties and have perused the materials on record, which includes the pleadings as well as the enclosures therewith. Advertisement so issued, it is apparent that the category that the type of LPG distributorship is Rurban. Full stop. At clause 1 C of the unified guidelines for selection of LPG distributors, the types of distributorship area have been defined. First, from a perusal of this, the definition of the type of distributorship area, it is seen that there are 4 different types of areas, distributorship areas. The first is the Seheri Vitrak. Which is a type of distributorship where which is a type of LPG distributorship located in urban area. service the LPG customers located within the municipal limits of the metro city/town and would be called Sehri Vitrak. Urban area have been the definition of urban area is incorporated from the term urban as per census 2011. The second type of distributorship area is the rural vitrak. From a very definition, it is apparent that the LPG distributorship would be located in the urban area and such distributor shall service to the LPG customers in specified rural area, generally covering all villages falling within 15 kilometers from the municipal limits of the LPG distributorship location and or the area specified by the respective OMCs. The third category is the Gramin Vitrak, which will be a LPG distributorship located in rural area. And the term rural have been incorporated from the census 2011. Fourth category is the Durgam Kshetriya Vitrak, whereby the LPG distributorship would be in difficult and special areas. Also finds it relevant to take note of that in clause 1G, the term towns have been defined. Unified guidelines defines the term towns to mean the remaining towns not covered under the metro city and city as defined in clauses 1E and 1F of the Unified Guidelines. This code further finds it relevant to take note of the final master plan, notified by the notification dated 19/10/2010. From a very perusal of the said master plan, it is seen that the master plan area of the Namrup town of Namrup was 28.37 square kilometers, which included revenue areas of towns and villages, including the Nagamoti Kheremia Gaon, this court finds it very pertinent at this stage to take note of as to how the final master plan Namrup final master plan have devised planning purpose to divide the areas falling within the master plan into two zones. Zone A is the urban zone, which comprised of the township of BVFC, APL and AACB, as well as the urbanized area adjacent to the township. In the said master plan, there is a rule, the second zone is the rural zone, which comprised of various villages, including the Nogamati Kheremia Gaon. From a further perusal of the said final master plan, it is also apparent to take note of that by this master plan, what is envisaged, that there would be planning carried out in phases. And this aspect would be apparent from
79, my lord.
the heading, inverted comma, plan implementation and enforcement contained in the final master plan. Of the above, this court finds it relevant to take note of the documents which were submitted by the petitioners, as well as the documents which have also been, which are relied upon by the respondents. The documents which have been submitted by the petitioner, certificates issued by the circle officer, certificates issued by the respondent number 3 and 4. The respondent number 3 have issued a certificate on 1st of September 2018 stating inter alia that the plot of land which the petitioner had offered falls under the demarcation area of Namrup Town Committee according to the master plan report prepared by the Town and Country Planning Department, Government of Assam. It is also seen that the same officer
Page 90.
on 5th of September 2018 categorically mentions that the plot of land so offered by the petitioner does not fall under the existing demarcation area of the Namrup Town Committee as on 13/7/2018, which was the last date for submission of the application form. It was also mentioned that the village in which the plot of land is situated has been shown and has been earmarked under the demarcation area of the Namrup Town Committee according to the master plan report of the Town and Country Planning Department, Government of Assam, and published in the Gazette notification dated 19/10/2010. This court also finds it relevant to take note of the certificates which were issued by the Namrup Town Committee. Respondent number 4. On 27/8/2018, the Namrup Town Committee to the chairman and the executive officer informed that the plot of land offered by the petitioner is not within the demarcation of the Namrup Town Committee. It is further seen that 3 days later, the said officers of the Namrup Town Committee though reiterates that the land offered by the petitioner is not within the demarcation of the Namrup Town Committee. But as per the final master plan for Namrup 2025 prepared by the Town and Planning Government of Assam, the revenue area wherein the land submitted by the petitioner falls, land offered by the petitioner falls, is included in the master plan for Namrup. Full stop. From the discussion of the above materials, full stop. This court further finds it relevant to take note of the definition of census, a definition of urban, provided in the census of 2011. The definition of urban area is as follows. এইখন document আছে। এইখিনি, হ্যাঁ? From the documents which have been enclosed by the petitioner as well as the respondents, it is clear that though the Nagamati Kheremia Gaon is included in the final master plan of the Namrup, but it has been treated master plan within the rural zone. The documents which have been submitted by the respondent number 3 and 4 further makes it clear that the land which have been offered by the petitioner is yet to be demarcated within the Namrup Town Committee. Under such circumstances, the first part of the definition of urban area as mentioned in the census of 2011 is not satisfied. It arises as to whether the land can be brought within the ambit of the second part of the definition of urban area as per the census of India 2011. For the purpose of the second application of the second part, there is the requirement that there has to be a minimum population of 5,000 and at least 75% of the main working population engaged in non-agricultural pursuits and a density of population of at least 400 persons per square kilometer. These criteria which is required to be fulfilled Now the question arises as to whether the Nagamati Kheremia Gao population, Gao, would come within the ambit of the second category. In terms with the documents, so placed by Mr. M. Sharma, the learned counsel appearing on behalf of the respondent number 1 and 2, it is seen that the population of Nagamati Kheremia Gao, as per population census 2011, was 1686. The Nagamati Kheremia Gao is administered by Panchayat, is administered by the Nagamati. What is the village panchayat? Any idea? No.
As per the advertisement, my lord,
There is a mention here. Taking into account the above, it is the opinion of this court that the
Namrup. Now Panchayat is Namrup.
huh?
Namrup.
Namrup.
for the advertisement.
No, not as per that. It cannot be the Namrup Gatwa. It cannot be the Namrup Gatwa.
Page 18, your lordship. Gram
Huh?
Panchayat, page 18 of my application, your lordship. Gram Panchayat is written as Namrup. Serial number 9. G.
Serial number G.
1G. Gram Panchayat, Namrup. Block is Naharani.
Taking into account the above, it is therefore the opinion of this court that the petitioner's offered land do not satisfy the requirement in terms with clause 1C, do not satisfy the definition of Rurban Vitrak as defined in clause 1C of the Unified Guidelines for Selection of LPG Distributorship. Under such circumstances, this court does not find any merit in the instant proceedings to interfere with the impugned order dated, impugned email dated so and so,
29-2, my lord.
29 impugned communication dated 29/9/2018, enclosed as Annexure 11 to the writ petition. Accordingly, the writ petition stands dismissed, interim order stands before. পিছত অৰ্ডাৰত লিখিলে মই লিখি দিম XYZ কৰি দিম হা BCD কৰি দিম
Well, the other day, some doubt was expressed by my learned friend as to whether in 2004, he had, yes, sorry, my HPC gets,
this one
this one will not that. Milad, only thing is, Milad, I find that under the act, there is a provision for conciliation, Milad. There is a provision for conciliation, Milad.
ICC
ICC.
Who there, everything can be done, not here.
That can be done.
It's-
Otherwise,
it's
there's
no
a
point
mandate of the
here,
act.
Because you see, there is a way, not here, but in many other cases, it may have a lot. Go there, he may not give evidence, you may go.
No, we'll go there, Milord.
You will like to proceed with your inquiry, and if there, as per the provisions of law, thereby providing conciliation.
The
There-
ICC first has to complete the inquiry proceedings because it was left.
There are
to-
two types of inquiry. The first inquiry is to be done by the ICC. And that inquiry also has to have the participation of the petitioner.
Hmm.
And more particularly in view of the order passed by Justice Surana. Because earlier you had passed an order. That order has been, or recommendation, that recommendation has been interfered with
Yes.
by this court, thereby granting the petitioner an opportunity. Under such circumstances, you have to go ahead. Go for a fresh inquiry.
In terms of section 10, Milord.
Because the inquiry was left at the stage of examination of and cross-examination. Examination was done, cross-examination he has to file.
No, it will be
Lordship
gone
may
from where?
examine The review order, my lord.
Huh? If the member of the ICC is no longer available for the reason, it will be available. To avoid in the petitioner is directed to produce a certified copy of the along with his written statement, physically or through email addressed to the competent who on receipt of this before it so and
Page
so.
53.
Examine the witnesses on such date.
53 of
Detailed
lead petition.
to the ICC to deny adjournment petitioner. So this is the stage.
আমার চিঠিখন ক'ত যিখন আমি পিছত
Kindly come to page 53, paragraph 26.
para 6, 26. 2 to 9.
Nowadays, Mr. Chaudhary, we don't get good papers.
Oh, Prasipa started that.
No, here.
Oh,
We don't get properly to, most probably the junior councils are not providing good copies to you also. So here paragraph 26 says, as per 7(4) of the rules, the petitioner was entitled to be heard in compliance with the principle. Hearing the petitioner in the jail cannot be said to be compliant. Therefore, in the light of the discussions above, the court is to consider that the said ICC report along with its recommendation is set aside in court. Matter is remanded back to the internal NRL for a fresh proceedings by giving the
Yes.
petitioner a last chance to file written statement of defense. So it will be from the
It'll
written
start.
statement of defense. And have you submitted the written statement of defense?
No. We'll file. In the meantime, Milord, this development took place.
Okay, you may take a written statement of defense and then whatever may be, and you may take all the pleas which you have taken here. Mr. Chaudhary.
Milord, if a
Take the
lordship will,
pleas which you have taken here.
yes. I'll take there, yes. Milord, actually at page 84, our application is pending, Milord. This is by the complainant.
Closure of the petition. Right.
The criminal proceeding was quashed.
Let's see the.
Section 10, Milord. In fact, in view of the order of this honorable court, Milord, we are exactly at the stage covered by 10(1). এখন নাই নেকি? নাই? এখন যা, যা পেয়ে দেখি। এখন মোক আমাৰখন দি থাক। এখন লওক। Section 10(1), Milord. internal committee or as the case may be, the local committee may, before initiating an inquiry under section 11 and at the request of the aggrieved woman, take steps to settle the matter between her and respondent through conciliation, provided that no monetary settlement shall be made as a basis. Where settlement has been arrived at under subsection 1, internal committee or local committee, as the case may be, shall record the settlement so arrived and forward the same to the employer or district officer, as the case may be, so and so. Internal committee, as the case may be, shall provide copies of the settlement as recorded under subsection 2 to the aggrieved woman and respondent. When settlement is arrived at under subsection 1, no further inquiry shall be
No,
conducted.
one thing, what is this, there is a rejection of the settlement is what? Kindly see the email, kindly come to page 86.
86, Miller.
Copy of the email dated Iman by the ICC rejecting conciliation. What is that order?
Actually, during the pendency, she filed for conciliation of the matter during the pendency, but by that time, conciliation was over. We have moved to section 10. 11.
No, no, my lord, it is not like that. In view of the order of this honorable court, in any case, now the matter has to go to
Now,
the.
now my,
from
tell
the-
me one thing,
Ah,
is you are to go ahead afresh.
ah.
Lordship of what?
Now, my question is, this incident was reported when was the fire?
1 second. my lord.
2021, my lord.
Huh?
2021.
28/7/21.
28/7
28/7/2021.
Hmm.
And when was the petitioner arrested?
on
It is
19/8/2021.
19/8/2021. When was
and
the
the
con-
ICC, the proceeding started on 10/8/21.
Huh?
10/8/21.
He was arrested on 19/8.
Yes.
19/8.
The 10/8/2021 ICC proceedings started.
Yes.
Now, when is the order of conciliation? And when was he released?
My lord,
He released
the petition bill order to কিমান আছিলে? নাই, conciliation হোৱা নাই.
No, rejection 104, annexure D, my lord.
Huh?
Page number 104, additional affidavit filed by number 5, my lord.
Ah.
According to this email, my lord, I was informed, I am the complainant in this case, my lord. 104, my lord.
নহয়, নহয়, বেইলটো কোন তাৰিখে দিছিল আমাক? বেইল অৰ্ডাৰ।
My
In
question is-
fact, Mr. from 10/8/21 to 5/10/21, 14 witnesses were examined.
10/8 to 5/10. No, no, I'm not on that.
Yes.
Now, the complaint was filed on 28/7/2021.
Yes.
When was the complaint filed?
Yes, 28/7/21.
FIR and complaint both same day.
No.
FIR is on,
19
FIR is filed on
19/8,
subsequently, my
2021.
lord.
19/8.
19/8/2021. And
On
on
same
that
day,
day, he is
He
arrested.
is arrested.
Now tell me, when was the conciliation carried out?
No, no conciliation.
Conciliation carried on before that, my lord, the lordship.
মই নাই আৰু ক'ৰ পৰা conciliation যাব?
I applied for conciliation, my lord, that was never allowed,
It is subsequent.
my lord.
My question is, when was the conciliation carried out? Because there is a requirement as per law
Hmm.
that there has to be first conciliation, then
Yes.
to move.
May, my lord, May.
But then
May
one
board
says,
district.
the
So it was
internal
never
committee or the, as the case may be, the local committee may, before initiating an inquiry under section 11, and at the request of the aggrieved woman, take steps or settle the matter before her, between her and the other through conciliation. So at that point of time, she did not.
Hmm.
Because it seems that thereupon on 19/8, she filed the FIR and all these things.
Hmm.
So there is no scope for conciliation
Yes.
process, it did not go into.
Yes, correct, that's correct. And lordship, after that review order,
But the question is, once the conciliation proceedings is not there, you don't go ahead. Once you start the inquiry, can't you go back to the
Why
conciliation?
not?
Where's the bar?
Yes.
Lordship, section 10 will see, my lord.
Ah.
The internal committee, or as the case may be, the local committee may, before initiating an inquiry under section 11, and at that request of the aggrieved woman, take steps to settle the matter between her and the respondent through conciliation. Before initiating section 11. So by the time inquiry has started, witnesses were examined. So that is the position.
No, now in view of the honorable court's order, we are back to 10-1 position.
And the authority has
You'll be back to 11-1 position,
My lord.
not 10-1, 11-1.
No, actually, when, my lord, it will start, no, yes, technically that is there, my lord. But now that scope is still open. My lord, it's not that, my lord, I don't think it could be the intention of the legislature that even at the, interjection of the honorable court, my lord, that position cannot be, my lord, retrieved. I don't think that is the intention, my lord.
because after the passing.
Let us see the other judgment which has been.
It's a fact, my lord,
There is
supposing,
another procedure given
Ah.
after this, which has been given by. Tomorrow at the judgment.
lordship judgment, my lord. এখন এটা আছিলে,
But there I have quoted, what are the procedure to be followed?
1 second. Is it Alok Kumar Ghoshal, my lord? Sorry.
Because Numaligarh refinery will come under the CCS thing, the central government's thing. huh? Oh. মুখ এখন বেলেগ এখন দিছি না।
Para, I think 34, my lord, para.
Mr. Chaudhary, this type of what is wrong? I think because of this ICC in your
No,
side,
no, no,
it's a very
no.
disastrous state of
Oh,
affairs.
it will fall. That will get. I have not done. Normally for settling draft, we use these papers, my lord. Not for judgment.
Kindly come to page 21 of 33. Need for investigation.
Yes, my lord. The complaints committee may act on the complaint of sexual harassment when they receive them directly or through administrative authorities, or when they take cognizance of the same suo motu. As per section 9(1) of the Act, the agreement or the complainant is required to make a complaint within 3 months of the incident, and in case there has been a series of incidents, 3 months from the last incident. The complaints committee may, however, extend the time limit for reasons to be recorded in writing if it is satisfied that the circumstances were such which prevented the complainant from filing a complaint within the stipulated period. As mentioned above, the complaint of a sexual harassment are required to be handled by the complaints committee. On receipt of a complaint, fact of allegation are required to be verified. This is called preliminary fact-finding inquiry or investigation. Complaints committee conducts the investigation. They may then try to ascertain the truth of the allegation by collecting the documentary evidence as well as recording statement of all possible witnesses, including the complaint. If it becomes necessary to issue a charge sheet, disciplinary authority relies on the investigation for drafting the imputation as well as for evidence by which the changes are to be proved. Therefore, this is a very important part of the investigation. Paragraph 9, 10, and 11 of the OM clarify the dual role of the ICC. In the light of the proviso to Rule 14(2) mentioned above, the complaints committee would normally be involved at 2 stages.
That's all. What they have to do as per this, there
Yes.
are 2 phases.
Dual role.
First role is the inquiry.
ICC inquiry.
Although section 11 does not do so, but in view of the judicial AI in Sohail Malik,
Ah,
and prior to that, the other judgment of Justice Pardiwala,
ah.
It has given a dual role, and because of Justice Patiwala judgment, it has led to the, what you call, amendment to the CCS rules.
Ah.
Now, what has happened is first they will make a preliminary inquiry.
Preliminary inquiry.
So 11-1, now we are at the stage of 11-1,
Ah,
the preliminary inquiry.
preliminary.
On the basis of that, as a report will be submitted to the Numaligarh refinery.
Ah.
The Numaligarh refinery thereupon shall take a decision
Whether to go for DP.
DB or not.
Ah.
Once the DB is taken, then again the ICC becomes
But
the
not-
inquiring
no,
authority.
No, it can, both ways. It can also appoint in the same into ICC.
No,
as
no,
the inquiry
no, then the ICC becomes the
Inquiry report authority.
Once the ICC, then the punishment is to be given by Numaligarh, but ICC becomes. So this is a more
The
elaborate
difference-
process.
the
There are two.
difference from Megha Kotwal is, my lord, there it was said
Ah.
that this itself will be treated as an inquiry report. Thereafter, from that stage, the proceeding has to follow. In
No,
Megha Kotwal's
this
case.
you will find it at
Yes.
page 63.
No, my lord, last paragraph, Harry Sohel.
No,
case.
there, 64 you see, after the fact-finding inquiry is conducted by page 22 of 23, 33.
Yes.
So the fact-finding inquiry is conducted by the ICC,
Hmm.
paragraph 12, so and so of the OM,
Hmm.
provide for the power of the disciplinary authority to examine the report
Yes.
and decide as to whether a formal charge sheet needs to be issued or not.
And at what stage?
At
Yes.
which stage an inquiry is to be conducted.
Hmm.
The said paragraph so and so are quoted.
Hmm.
Then it says, on receipt of the disciplinary authority so and so they are putting it. It is clear from the OM, the paragraph 65, of the central government that in respect of central government, inquiry into the complaint of so and so is to be conducted into two distinct ways. First,
Hmm.
the ICC is to conduct the fact finding or preliminary investigating the veracity. Thereafter, the report or recommendation of ICC is to be sent to the disciplinary authority, which shall examine and report and shall decide as to whether formal charge, upon issuance of a formal charge sheet by the disciplinary against that, comes when the ICC is required. So the second again, ICC is required to act as an inquiring authority.
That's why it is
in the
said dual
form
role.
under
Hmm.
the CCS rules in order to decide the disciplinary charge, which may or may not be imposed upon the employee.
In other words, my lord, the role of inquiry officer in a DP, it will
Hmm.
be taken over by ICC.
ICC. So therefore, this is what it is.
Now we are at the stage, my lord, now that preliminary inquiry is gone. We're at that stage.
It is at the stage of preliminary inquiry.
Therefore, where is the difficulty in conciliation?
So therefore, this has changed in view of section 11 was there.
Hmm.
But section 11 was worded in this manner. Now, in view of the judicial pronouncement in this other
Sohel
one-
Sheikh.
No, the first was the other one. Na. Medha Kotwal.
Medha Kotwal is the first one, my lord.
There is another judgment of justice.
That
Party.
Goa case, Goa.
Yes. From there and then in Sohel Malik, this is to be taken.
Yes. Aurelio Fernandez.
Aurelio. So in view of this Aurelio Fernandez and this, because of Aurelio Fernandez, this amendment happened. And thereupon, because you
CCS.
follow the CCS.
CCS rule, yes.
We have our own rules.
No, it's a parameter, yeah, my lord.
It's a experiment.
Therefore,
We have
you
a
need to
policy.
follow this. This is the way out. Because
And
this is a case of IIT. This,
Deal.
this Alok, this Ghosal.
And that was a case, my lord, distinction is in that case, Ghosal, she wanted the inquiry. And here, my lord, she is not complaining. In Ghosal's case, I think.
The complainant
A
wanted.
complainant wanted.
They did not stop anywhere to
Yes.
stop it.
And after the recommendation also, there is a provision for appeal.
Yes.
No, we then direct them to look into it
Yes.
and follow you proceed. He's withdrawing. So therefore, you now proceed as per the inquiry and take note of the judgment in the case of Sohel Malik.
Right.
There you can raise those issues.
Yes.
Heard Mr. Kane Chaudhary, the learned senior counsel, assisted by so and so. Appearing on behalf of the petitioner, Mr. J. Roy appears on behalf of learned senior counsel, assisted by so and so, who appears on behalf of the respondent numbers 1, 2, Three also. How are you pairing the three?
Internal committee,
The internal.
one,
committee.
two,
One and two. Mr. Swenso appears for respond number 4. And who is 5?
MK Das, my lord.
Who is 5?
The complainant.
No. Who is 4? Oh,
Or is the
Okay.
presiding officer, my
number
lord.
5. Number 5.
I'm the complainant. 5.
Mr. Inchori, the learned senior counsel, submitted that taking into account the judgment of the Supreme Court in the case of taking into account that directions passed by the learned coordinate bench in the judgment dated 26/2024 in WPC number 2163/2023. What is the review?
1 second.
The review order 58 to 63, Miller. $55 in fact.
In repetition, it's 750, 53.
Read petition, para 26,
Review was filed by whom?
By the petitioner, ma'am.
As well as the order dated 21/7/2025 passed in review petition number 160/2024. The petitioner would not like to further pursue the present proceedings and take appropriate steps before the respondent number 3, wherein the proceedings are presently pending. Mr. K. N. Chaudhary, the learned senior counsel, further submitted that the law is now well settled by the judgment of the Supreme Court in the case of Dr. Sohail Malik versus Union of India and another, reported in 2025 SCC Online SC 2751, whereby the manner in which the inquiry is to be carried out by the internal complaint committee is to be regulated. He submitted, the learned senior counsel submitted that the respondent number 3 and 4 is required to adhere to the directions so passed in the said judgment. This court have also heard Mr. J. Roy, the learned senior counsel, who appears on behalf of the respondent numbers 1 and 2, who submitted that the inquiry to be conducted by the internal complaint committee, that is the respondent number 3, shall be done so as per the applicable provisions of law. Mr. K. Chaudhary, the learned senior counsel, also submitted that withdrawal of the instant petition should not prejudice the petitioner to raise all such claims raised in the instant proceedings before the internal audit complaint committee. Taking into account the above, the instant writ petition therefore stands closed on withdrawal. The withdrawal of the instant writ petition shall not affect the rights of the petitioner to raise such pleas as permissible under law. Including the application of the directions so passed by the Supreme Court in the case of Dr. Sohail Malik. This court also have heard Mr. So-and-so, the learned counsel who appears on behalf of the respondent number 5, who insisted that the respondent number 5 wants to go for a conciliation. This court have given an anxious consideration to the said aspect. And taking into account that the provisions of the sexual harassment of women at workplace bracket prevention, prohibition and redressal bracket close Act 2013 is a welfare and a beneficial legislation for the purpose of protecting the rights under Article 14, 15 and 21 of the Constitution. The internal complaint committee, that is the respondent number 3, shall duly consider the request of the petition respondent number 5, if so made. I think that is enough.
Yes.
Deep breath. Yes, what is it? What is your stand?
The order assessor. আমার আছে নাকি? আমার কপি আছে, আমার দিব লাগা কপি আছে।
The board is there. And you are not there. Water resource is there.
We have vacated, madam.
Huh?
We have vacated, madam.
So water resource is not there. Irrigation?
Irrigation.
Irrigation is
is
occupied.
Lordship occupying, but it is a process of Lordship vacating the.
But you have informed that you have vacated.
Water resource.
Waters are already vacated.
You have vacated.
Who appears for the Khadi board?
Earlier standing council was there, madam. I don't know.
The Khadi board is removed.
No, that office is there. Office is there.
They say that they have purchased.
No. They are inspected.
They will
When they
persist.
purchase, why are they still paying in the name of the petitioner?
What will lodge?
So far as written in this instruction, probably
If-
land.
They say in 1965, they have purchased it from you.
Very good, your lordship. Then they will have to pay the compensation, your lordship.
They purchased it in 1961 by paying Delhi.
Let them show some sort of evidence, your lordship, document, your lordship. Mere saying that purchase, it will not do, your lordship. Because land still stands in the name of our predecessor. Still stands according to their own admission. They are saying that it stands in the name of Ravindra Borua, Mrigendra Borua and Ruby Borua. We are paying land revenue, your lordship. The revenue record says that we are still the owner of the land,
When did you pay?
lordship.
When did you pay the land revenue?
Land revenue, your lordship.
pay?
Up to
Did you
that-
last pay the land revenue?
Up to that land revenue we have paid, your lordship.
Because there was a accumulation of around 53,000 which was not paid. And therefore, it is the Khadi board who made the payment. They have not paid the land revenue. What is page 56 of your petition?
Lordship, annexure fifth, that B1, your lordship, annexure C.
This is of 2000.
In the year, your lordship, 2004, they served us notice, your lordship. Last revenue payment, it is on 7/1/2022. Annexure B. Page
So my question is, you have failed to pay.
Lodge. That is admitted.
So are you acquiring the land or you are handing it?
That instruction is not very clear, ma'am.
It's not that we are not concerned that instruction. On the last occasion, when the matter came up in the month of May, I say,
Lodge.
don't involve this additional deputy commissioner, they have no business of. Or somebody in the higher ups, like the revenue commissioner and secretary, revenue department and all who can take a call. The government of Assam has to take a. First of all, I also know, as I hail from nearby area,
Lodge.
this is a very precious plot of land. Any person, any private individual will jump. One of the most precious lands in the entire area. And it is a huge block of land of around 5 bighas something. 5 bighas? How much? How much is your land?
total land 22 bigha, your lordship.
See, 22 bighas. 5 bighas were sold, that is was being mentioned to Khadi board. But anyways, Khadi board has failed to do anything. My question is, this is a huge plot of land, 22 bighas in the center of Gauhati. Nowadays, we don't see because of the flyover, it's a different thing. Otherwise, when we just come up from our home, we used to see that entire building. So therefore, I think you need to involve somebody, not this type of people. Call your senior government advocate.
He is not present today, my lord. I have already.
Chalo. Call the additional advocate general, B. Gogoi. Wait. Wait for some time. Let him come. Now your matter intellect over.
Lordship, it got adjourned by the court itself.
Will you? Whoever takes it, does it at his own.
I think that's in the process.
Huh?
I think that's in the process. Whoever.
See, the thing is like this, which I thought about it. This section 67(4) is something like a, you can use the word parasite to section 67(2). Section 67(2) says for search and all this thing, search and seizure and all this thing. And it requires the reasons to believe. There has to be recording of. Section 67(4) is just, it is one of the part of section 67(2). If you don't go for search, seizure, maybe without going for a search, the question 67(4) does not. Then 67(4) says that in the circumstance you are, when you want to make the search, there is a person who is stopping you. By putting a wall or doing something to that effect, then you break open that thing. Or for that matter, he does not allow you. And you have those goods, you seal it. But it has a condition stipulated therein to the effect, when the access is denied by the,
Resistance has to.
now if the access is not denied by the person, exercise the power under 67(4) and no recording of reasons under 67(2). Exercise that will be proper. Secondly, can you seal without an order? You may very well say that, oh, he has a alternative remedy under section 67(6). But how can he go unless you have the order of, there's an order passed under 67(4). You are just pasted.
When my lord section 67.
What did you get?
My lord,
What did you get?
one my lord Gujarat High Court, one
Huh?
Delhi, one Gujarat High Court, one Delhi High Court.
Gujarat High Court judgment is Justice Patiwala's
My lord,
2020.
20, my lord, 20, my lord. Then my lord, one I have got my lord, Delhi High Court judgment, my lord.
Delhi High Court judgment more particularly says about 67(2).
67, no, my 67(4) also, my lord. Rajasthan High Court say about 67(2), my lord.
Rajasthan High Court did not interfere on the ground of alternative remedy under 67(6).
6, my lord. 67(6) does not
The
come.
matter is pending before the Supreme Court.
It was
The
fixed
Supreme Court
today
had
at
issued
2 p.m.
notice.
It was fixed today at 2 p.m. at Supreme Court, my lord. I have got the order, my lord.
No. They've gone to the Supreme Court and Supreme Court had put that particular question as the condition precedent that access was denied.
My lord. Yes, my lord.
The access is not denied, you cannot, and more particularly for a period of 4 months, not possible.
Supreme Court case is again now, Lordship, I just saw a few minutes back. It is going to be taken up again day after tomorrow.
Court may take whatever may be, that is besides the point. This court does not stop because of the Supreme Court unless the Supreme Court stays the proceeding,
My lord.
isn't it? What do you want to say? I said is right or wrong?
Yes, my lord.
You'll obviously say Supreme Court, while issuing notice, that is against the Rajasthan High Court.
Yes, my lord. Yes.
Categorically pointed out that question
Yes, my lord.
on the jurisdictional point
Whether
as to whether there was a denial of soil. In your case, there is no denial. You have made all the search and soil. 67(4) condition precedent is not. And there has to be an order. Everything has to be an order. You cannot just seal it just for example. Have you mentioned anywhere recording reasons that we have to seal it because his access has been denied?
Lordship, in the affidavit, simply we
What
have
about the
stated that
affidavit?
INS
Anywhere?
that
Anywhere?
record, Lordship, then I have to bring it because whether a specific reason to believe.
You knew it about this. No. Well, you see, his business has been stopped. He cannot even delay for one more day. And these are all laptops. There's nothing else. What you seized out there are all laptops here. Take the whatever the laptops or anything to the effect.
That can be done. Lordship may allow us just weeks time, then we will bring out everything, whatever basically the laptops and other.
You don't need to take the laptop. You take the scan and made a screen of it. I will
Backup.
have another thing to that effect. What is that called? Clone. You clone the. You can't keep a business stock. You don't. If you keep it a business stall, then how if he can't pay GST to you? How will you survive? We survive on the GST, isn't it, Mr. Chaudhary?
Yes, yes.
And the income tax.
My lord.
There's nothing else. He wants to pay. Well, do whatever you do. One thing, I give you. You do one thing. You have already seized. I give you 5 days from there, and then in the meantime, you see, the question of giving also does not arise. You have already seized it,
Yes.
and you handed over the possession of that laptops to whom?
Nope, it's still in the premises of the petitioner, only
Or
the
you
order
need
of.
to take it. You just cannot keep the room locked out there.
Yes, Lordship, after handing over INS 03 as per rule 139(4), it's still there, only the some of the files they have brought back. And the computers and everything are still there.
So you need to do the thing. You have to open it. You have to open it. In the meantime, after opening it, you take the whatever it is, and that is the only thing. Rikiti? Hello, I'll pass the order. Allowing him that just let me just think what to do. And the moment I allow him by passing an order, he'll have the access, and you have seized and not handed over the possession of anything. How to take care of that situation? You remove the order. I do one thing, I pass an interim order today. Open it, take whatever is required, and then
We will submit a report before your Lordship. We will submit a report within the time frame of whatever the Lordship fix it up in the interim.
Thursday. You open, take whatever you require from that in the presence of the petitioner. And whatever, because these are only some computers. Whatever is required, you take over it and submit a report and give an update on next date, Thursday. And then on Thursday, I'll ask you to open it in presence of the petitioner. Friday? Friday. Okay. This is an interim order, I'm passing it.
My lord.
Heard Mr. R.S. Mishra, the learned counsel appearing on behalf of the petitioner, Mr. B. Chaudhary, the learned standing counsel of the Finance and Taxation Department of the Government of Assam. The petitioner herein is aggrieved by the sealing of the petitioner's premises in purported exercise of powers under Section 767, bracket 4 of the Assam Goods and Service Tax Act 2017. the learned counsel appearing on behalf of the petitioner submitted. The search was conducted on
My lord, it was on 1/4/2026, my lord, 1st of April.
1/4/2026. And thereupon, in exercise of the powers under section 67(2) of the Act of 2017, an order of prohibition was passed, whereby informing the petitioner that it shall not cause to remove, part with, or otherwise deal with the goods as mentioned in the annexure attached to the said order. The goods, the goods which have been described in annex in the attachment to the said order are desktop computers, are number one, are one desktop computer and 5 laptops. In addition to that, 5 not, the 2 desktop computers and 1, 2, 6 laptops. In addition to that, 426 files were mentioned. The rest of the goods that is the printer, battery, inverter, air conditioner, and refrigerator do not contain any information which have any relevance to the search and seizure. You have challenged the search and seizure, no, na?
No, my lord.
Lordship,
The petitioner,
in Annexure 1 also there are other items.
what is it?
That was seized, my lord.
Some, there are also laptops, passbooks,
Where?
Annexure 1,
Page 27, my lord.
27,
It is a part of seizure memo, my lord.
What? Next one.
page 27.
27. It start from page 24, my lord. It's seizure, my lord, order of seizure.
So, in addition to that, various documents various books, documents, things were seized. By the separate order. Dated 1/4/2026 and marked as Exhibit 1 to Exhibit 105. Now, what have you done after seizing?
They've taken away, my lord.
You have taken it.
They've taken away.
Yes, yes, my lord.
So these documents are with you now.
Some of the documents are.
No, they cannot be. These are all digital signatures.
The signature.
And what else?
Passbooks.
So therefore, if you have seized it, you have to hand over, keep it, either have it with you. The moment you seize it, it is with you.
Yes,
And thereupon, you have not handed over to anybody. And you cannot keep it in anybody's place. It has to be in your custody.
some of the things are with our custody, and some of the things are still there, Lordship, in the premise of the petitioner.
Now, the things which are available in the premises are at page 39, my lord. These are
Now,
available-
this cannot be. Now, once you seize it, you have to give it to somebody, na?
Yes, my lord, because in serial number 65 and 66, another two laptops are there. Lordship, and in the,
No, understood. So you have seized it.
yes,
Once you seize it, what is the effect? It is with you. Now here you see there are two things. One is the seizure and one is the prohibition. Now the prohibition is in page 39. The other is the seizure.
yes, ma'am.
So the moment you are seizing it, it is with you. There's no quarrel with anything else. Anyways, I'm giving you that opportunity. It is very pertinent to take note of. That the respondents have also put us or have also pasted outside the office of the petitioner an order of prohibition in other words, sealing the petitioner's office. Issue for which the present writ petition has been filed. It's challenging the orders passed by the learned, challenging the jurisdiction of the respondents. In the petitioner's office premises. Mr. R.S. Mishra, the learned counsel, submitted that breaking open locks to a premises and or to seal a premises is only permissible when the access to the premises is denied. The learned counsel submits that there is not a single whisper in the stand of the respondents that the access to the petitioner's premises was at all denied. Legal counsel further submitted that keeping the office premises sealed for the last 4 months, merely on the ground that some of the laptops, some of the goods which are mentioned in the order of prohibition are lying inside, is an arbitrary and an unreasonable action and beyond the jurisdiction of the respondent authorities. This court have also heard Mr. B. Chaudhary, the learned counsel, appearing on behalf of the parties, on behalf of the Finance and Taxation Department, who submitted that while conducting inspections, search and seizure on 1/4/2026, various forged documents could be traced out. Could be recovered. Apart from that, there were various, in addition to that, the petitioners have also resorted to various frauds, willful misstatement of facts, as well as suppression of facts in order to evade tax. And as such, it is required that the materials oblique goods which could be which the respondents could trace out is kept under lock and key till the completion of the inquiry. This court have given an anxious consideration to the respective submissions, and it is the opinion of this court that the power to steal or break open the door of any premises or break open any almirah, electronic device, box, receptacle in which any goods, accounts, registers or documents of any person are suspected to be concealed, conferred upon the officer authorized under section 67(4) is to be exercised when access to such premises, almirah, electronic devices, box or receptacle is denied. Because of the fact that the respondent authorities have issued an order of prohibition of certain goods which have been mentioned in the order of prohibition, which have been mentioned in the list attached to the order of prohibition. Or for that matter, there has been certain search been conducted and a seizure, and certain documents have been seized, which have been mentioned in the list attached to the order of seizure. cannot be a ground to keep the petitioner's premises under lock and key, petitioner's premises sealed. Unless the condition precedent for exercise of the such power that the access to such premises, Almirah, electronic devices, box or receptacle was denied. Further to that, this court does not find any justification on the part of the respondent authorities to continue to keep the said premises sealed for a period of 4 months on the pretext that the goods so mentioned in the list attached to the order of prohibition are lying inside the premises. Accordingly, this court disposes of the instant we dispose it. Instant writ petition with the following observations and directions. Respondents, who is the authorities of who is the officer?
Lordship, respondent number 4. Intelligence, GST intelligence.
The respondents herein, the respondent number 2, 3, and 4, and more particularly the respondent number 4, is directed to no, we keep it pending. Then only things will happen. Then it will pass certain interim directions till the next date. The respondent numbers 1, 2, 3, and 4, and more particularly respondent number 4, is directed to deseal the office premises of the petitioner located at
It is given, my lord,
where?
paragraph 2, my lord, Station Road, Bokajan Bazar, Bokajan Difu, Karbi Anglong.
Huh?
Paragraph number 2, my lord. Last 3 lines, my lord.
At Bokazan Bazar, Bokazan, Ifu, Karbi Anglong.
Station Road, my lord. Station Road, Bokajan Bazar.
Within 3 days from today, on or before 7/8/2026. In presence of the petitioner. The respondents herein shall be at liberty to take the books, public documents, things seized if lying within the premises. As mentioned in the annexure 2, the order of seizure dated 1/4/2026.
It will be order of prohibition, my lord.
Insofar as the order of prohibition is concerned, the respondents herein would be at liberty to take the hard drives. You take the hard drives or clone. Take the hard drives of the desktops as well as the laptops referred to in the annexure attached to the order of prohibition, or may clone the hard drives of the desktop oblique the laptops referred to in the annexure to the order of prohibition. The respondents further would be at liberty to take the files, the liberty to take the 426 files if the same are necessary for the inquiry, investigation and inquiry. Upon doing so, upon completing the same, the respondents, more particularly the respondent number 3, shall pass and effect an order, shall issue a communication to the petitioner intimating that the premises have been desealed. The aforesaid aspect be placed before this court on the next day, that is on 13th of August 2026. You do it by 11th, huh? Yes. Bukazan is tomorrow. 11th and day. Yes. Mr. Gogoi, you see this matter, we need to inform in the higher ups out there what is to be done. This is a huge chunk of land at the center of Gauhati. That's the Chanmari Flood Control Office. Government may like to keep it because of the fact that nowadays these type of lands are not available. Or do whatever you feel like. He doesn't want the land, he wants the compensation. Isn't it?
Large compensation, full compensation.
So therefore, getting this type of land is impossible now. He's giving an offer to that effect. Why don't you take it? And because nothing could be found, all along their names have been there in the register, everything is there. Even the Khadi board is paying the land revenue, which I could see from the documents Ms. Bormon has placed. Are documents wherein it is clearly shown that these documents are that they are still paying in the name of Mrigan Borwa. That's the father of one of the petitioners. So therefore, you need to take a call, to ask the revenue department or the highest authority to take a call on this. Because this land, if it goes out from the government, you can't get it. Yes. 22 bighas. I don't know.
Will give us some time, some indication in the order also, because the minutes,
Because last time also I told Ms. Bormon that you keeping this with the air of the additional deputy commissioner would not do anything. Yes, the government is not serious, then otherwise we pass an order the evicting these people. Government. Already what has happened? Irrigation is in the process of going away. Lots of water resources left. You are having the Khadi board. Khadi board claims that they have purchased in the year 1961, but nothing. There's no such document.
No document, no sale deed, your lordship. What is the amount paid? At least sale deed number, etc. Nothing.
Khadi board is not. Even the Khadi board lately also have paid revenue in the name of so and so. They have never even tried to make because they don't have a document. One managing director of Khadi board says that I remember in 1961 this land was purchased. That is one of the documents. That is not due.
Clause 3.
Huh?
Clause 3 of annexure B.
No, these documents which today it has been placed. You see these documents. See this document annexure A as per my notes. Revenue Minister, he has written by, since the date of purchase of the land, the board is in possession. Had not been corrected since 1961. No sale deed, nothing. And this is a 5 bigger plot of land. You are also having that inquiry commission of the yes, I think the circuit there. Yes. You want to give it up and have it somewhere else so that he can have the land back?
Well, the government money.
Huh?
2, 3 departments are involved as on that matter.
The other departments are giving up. But Mr. S. Ali, the learned counsel appearing on behalf of the petition. Mr. B. Gogoi, the additional general appears on of the state of Assam. Pursuant to the order passed by this court on 19/5/2020. A minute of the meeting dated 27/7, minute of the meeting dated 1/8/2026 have been placed. The manner in which the respondents are taking up the matter, in the opinion of this court, is not at all satisfactory. In the instant case, the petitioner are not insisting. In the instant case, the petitioner are espousing their rights under Article 300A of the Constitution. Thereby, asking the respondents herein either to vacate the land or the state may acquire the land by paying due compensation. Mr. S. Ali, the learned counsel submits, or the petitioner submitted, that the petitioners are not adverse to the petitioners are more inclined if the land is acquired and the payment of compensation is made.
Alternatively, you also release of the land. Prayer.
Turned out there. But your main thing is this, no? Buy the land and pay compensation first. Taking into account this court is the vicinity in which the land is situated, the locality in which the land is situated, and the land being a large tract of land and measuring around 22 acres. Record received from the records that the respondents herein have not shown any seriousness in either acquiring the land by paying due compensation, and there has been no materials also placed which should show that the respondents have any right to remain in possession of the land Mr. B. Gogoi, the learned additional advocate general, submits that he would take it up with the revenue department of the government of Assam. As well as which department, Mr.?
Handloom and textiles.
I know, I know.
Khadi board.
Huh?
Khadi board.
No, Khadi board, nothing. He also doesn't have anything. You have to take it up with the revenue and which department? As well as with the district administration, Kamrup. Huh?
Let it be my lord, revenue department, they will take a call.
Revenue department. As to what steps the government of Assam would like to, state of Assam would like to take in respect to the land in question. This court also takes note of that the instant petition has been already pending for the last 4 years. And there is a requirement for an early resolution of the dispute. Accordingly, this court fixes the matter again on 17th of September 2026. In the meantime, the respondents shall place their instructions and or file their affidavits on or before 14th of September 2026. It is observed that in the circumstance, there is no proposal on the part of the government to acquire the land. There is no inclination, serious inclination of the government to acquire the land. This court shall take up the present proceeding on merits. The council, no case.
So, Mayor,
I will rely on Brahmaputra tele my lord, or Lordship, my lord, regarding maintainability. In challenging my lord, so-called notices of the.
my contention is that a matter has already been decided by the competent authority, cannot be taken up again on the same grounds.
Huh?
They have already decided my case. They have already issued a so-called notice on 9/4/2025, Annexure B, page 15. So-called notice for cancellation of registration. Whereas on the basis of information which has come to my notice, it appears that your registration is liable to be cancelled for the following reasons. Others. Remark. Registration is suspended pending submission of requisite documents by the taxpayer and field visit report of the jurisdictional superintendent of state tax. The proceeding for cancellation of registration is initiated on account of intimation by the apex office on date so and so pertaining to receipt of input tax credit from non-existent business entities. The suspension may be revoked on the basis of proper compliances by the taxpayer. After this, they have sent a summons.
My question is, have you filed your reply?
Lordship, I am before the court to invoke
Have you filed a reply?
reply for the earlier we have replied.
In this so-called notice, have you filed your reply?
In this after the DRC, after the issue of the DRC, there is any so-called
There is no
on-
stay
yes, we have filed a reply. It is in page 26.
against the registration cancellation.
Yes.
I'm asking you, do you understand the difference between a notice under section 26 and a notice under 73? Do you understand or not?
Yes.
Have you ever gone through the act or not?
Annexure H,
Mr. Counsel,
Annexure,
do you have the,
yes.
tell me, under when section 73 is issued?
73, they have not relied, they have relied on 74.
When 74 is issued?
For the short payments of the taxes or non-payment of the taxes.
And
Let me read it out. 74 pertaining to the period of financial year so and so, not paid or short paid or erroneously refunded, or input tax credit wrongly availed or utilized by reason of fraud or any willful misstatement or suppression of funds. So this matter relates to some
Now, Mr.
transactions.
Mr. Khan, my question is, what I'm thinking is, when you are making this unnecessary argument, is to how to give you some relief. Not in that as to whether can I permit you to file a reply. Is what is my consideration. Good. You have not obtained a stay from this court also. You pass an order in the meantime. Why?
Because of the pendency when.
Mr. Gogoi, I don't understand one thing. What is wrong with the departments? That day also I found out that departments are not bothered of passing those orders. Why haven't you passed this order? Who will take care of the limitation? If it is a case where 5 years is over, then what will happen?
Lordship, may I take the Lordship to page
Because
30?
this is not a case where I'm not going to entertain. It is a case for dismissal. Order which you have placed is a order by which there is a challenge to a section 73 order in original.
Including the so-called.
This is the case he is coming against the show cause notice on the basis that the proceedings under 26 for cancellation of the registration have not been. Yeah.
No, for the cancel of the
this is
registration
not
on
the-
the same facts or non, the facts are same.
It cannot be. It is no, because section 26 notice is issued only for the purpose of registration cancellation on account of some of the many reasons. First, if you have not submitted your return, there might be reason as to whether you have violated some terms and conditions of a contract of the act. These are the various here. But the section 74 is for the purpose when there is a fraud committed.
Actually, Lordship, legally speaking, 74 is not applicable in my case. My case relates to
Can I
transaction.
decide that? Can I decide that?
Yes, Lordship,
Hello?
section 74,
Hello.
let me take to Lordship, section
I'll help
74.
you when your client have chosen you. Anyway, heard, Mr.
Lordship,
M. Khan, the learned counsel appearing on behalf of the petitioner. Dismissing it.
Lordship, may,
No. Mr. So-and-so appears on behalf of the respondent numbers 1, 2, and 3.
one opportunity may be granted.
The present petition has been filed by the petitioner challenging the notice issued the notice dated 4/10/2025 issued by the respondent number 1 under section 74 of the Assam Goods and Service Tax Act 2017. Ground for the financial years for which years?
2025. 24 and 25.
Lordship, for transactions of 24, 25, they cannot issue a notice under section 74. It is to be 74A.
For the financial year 2024-25.
Right.
Next. Mr. M. Khan, the learned counsel appearing on behalf of the petitioner, submitted that the proceedings under section 74 of the Act of 2017 could not have been initiated. Ground that previously a proceedings was initiated for cancellation of the registration, and the petitioner, upon submitting the reply, it proceedings for cancellation of the registration was dropped by an order dated 9/5/2025.
9/4.
Full stop. The learned counsel appearing on behalf of the petitioner therefore submitted that fresh proceedings under section 74 of the Act of 2017 could not have been initiated. The submission so made by the learned counsel appearing on behalf of the petitioner is fundamentally misconceived and appears to be fundamentally misconceived, inasmuch as the proceedings for cancellation of the registration is completely contrary to a proceedings for adjudication on the question of non-payment of tax or short payment of tax or being erroneously refunded, or where input tax credit have been wrongly availed or utilized by reason of fraud or any willful misstatement or suppression of fact to evade tax. It appears that the petitioner, under such circumstances, the instant with petition is has no merit, for which the writ petition stands dismissed. Would you like to file a reply to that notice? At the time of dictating the judgment,
What's my registration may be restored because they have already decided the registration issue. About the tax, I can file the reply. But for the part of registration, that show cause notice for cancellation of the registration, they have issued twice, which was already decided. So
no,
registration,
Mr. Counsel, there are different reasons for which it may happen. Your registration may be cancelled if you don't submit within 6 months.
sorry, sir, but my registration, both the show cause notice.
Has your registration been cancelled?
That's
So
fine.
it is there. So why you are asking that?
My submission is that on both the show cause notices, the transactions referred to that.
You want to file your reply or not? Answer that. At the time of dictating the judgment, Mr. Khan, the learned counsel appearing on behalf of the petitioner, submitted that on account of not providing proper legal advice, the petitioner should not suffer, and therefore the petitioner should be granted an opportunity to file the reply to the show cause notice dated 4/10/2025. Mr. V. Gogoi, this court inquired with the learned counsel, standing counsel of the Finance and Taxation Department of the Government of Assam, as to whether any order has been passed pursuant to the show cause notice dated, impugned show cause notice dated 4/10/2025. Mr. B. Gogoi, the learned additional advocate general, submits that to his instruction no order has been passed. In pursuance to the demand come show cause notice dated so and so. Accordingly, this court disposes of the instant petition with the following observations and directions. The challenge to the demand come show cause notice dated 4/10/2025 is without any merit, and accordingly the said challenge stands rejected. Number 2. Bench of justice, this court grants the petitioner an opportunity of 30 days from today to file reply to the show cause demand come show cause notice dated 4/10/2025. Raising all such contentions as permissible under law. Number 3. Taking into account that this court had put the clock back, thereby permitting the petitioner to submit the show cause notice this court observes that a period from 5/10/2025 till date be excluded while computing the period of limitation for passing the order in terms with sections in pursuant in respect to the adjudication. In respect to the adjudication carried out in pursuance to the show in pursuance to the in respect to the adjudication to be carried out on the basis of the show demand come show cause notice dated so and so.
Proceed. My one humble submission may be recorded that section 74 notice is not applicable for the transactions of 2024-25 and later. So this section 74.
This court further imposes the cost of rupees 1 lakh upon Mr. M. Khan, the learned counsel appearing on behalf of the petitioner, for unnecessarily spoiling the time of this court. The said amount be deposited before the registry of this court within 15 days. Within 15 days, full stop. An affidavit of compliance in that regard be filed.
That
On
will
the
be-
cost,
No, no.
Well,
No, sir.
there is one more show cause which is not chilling. There is a show cause dated 4/9 regarding cancellation. That he may also respond to that also, my lord. Which are not challenged in the writ proceeding.
Yes.
no. 4/9 was dropped.
The second
Nine,
one,
9 for what, bro?
9/4.
9 for was to.
4/9 is that also you can reply, man. It is a show cause. So you will add that part also.
4/9 is what? No, in this only he has given. You see that particular document. The 74 document categorically mentions that. Na? See the prayer. See the why he has been show cause.
Background.
There is a mention, my lord, regarding this reply to the show cause, yes. But it is my.
There are 5 counts, including cancellation of the year.
The reply has been considered here, my lord, which was submitted in the earlier.
Filed it also. See the fifth one. Please see page 33.
Yes.
You are called upon to show cause why the ITC should not be this. The interest so and so registration should not be cancelled under 21B. It's there.
Yes, registration should not be cancelled under 20.
It's there. So therefore, you should read it properly. Yes.
Abhilash.
Oh, no time today. I think I'll CAV this. And what happened to Taran?
This is the order, my lord.
What imposition?
Same, exactly same.
Despite a minor.
No, no, same, minor, of the.
The Nazir
increment
and
is also there.
same.
Uh, reduced to the lower time scale of pay from BP so and so to BP so and so for a period of 3 years. With effect from so and so with further direction, they will not earn increment of pay during such period and on expiry of period. The reduction will not have the effect of postponing his future increment of pay. It's in verbatim to the order that has been passed in the case of petitioner, barring below the amount.
Lordship, my submission stands that it's not with regard to cumulative effect. My submission stands that it is not with regard to cumulative. As for me, it's one major and one minor, my lordship.
No minor. It is one only.
Cumulative,
Major. There is only one
One
major.
major.
There is no minor business.
my lordship.
There is no minor. So that is here also, then also here also Taran will
If-
say minor and major.
It's not come for challenge, my lordship. It
Not
is-
necessarily. There is only one punishment, major. Reduction in
Lower time scale of pay.
Reduction in pay.
Pay.
Reduction in pay.
Earn increment.
reduction in pay comes under
Reduction pay comes. below.
seven four.
7(4).
Reduction to a lower service grade or post or to lower time scale or to lower stage in a time scale. I think we complete, hearing complete,
my
judgment
lordship.
reserved.
Okay.
One judgment I had, PC Chaturvedi with regard to power of judicial review. If your lordships wants, my lord, I can just see that much only, nothing more than that. In DP matters. Otherwise, lordship is aware of the legal position.
What?
Regarding, my lord, to what extent we can go in a discipline that PC Chaturvedi lordship is aware that. The lordships require and just. be-
Problem is not there. The problem is you are giving impunity to the judicial officer. It's not this thing. It's not a simple thing like any other office. It's a different thing. But here you are giving impunity to this immunity to the or doing nothing as against the same judicial officer. He goes scot free. It is his mistake. He has to own to his mistake, like I do. Whenever it's a mistake, I do it myself. It is my mistake. I have to do it. It is my responsibility. But if the judicial officer does not own to it and puts it on the blame of the office, and that too after writing an order to that effect, that this is a case where kindly stay the order, pass the decree in title suit number so and so. Really? Why has he not mentioned about the titled execution case number so and so?
Far as proportionality is concerned, on the last occasion also, it was my my lord submission before your lordships that I leave it to your lordships, my lord. That is, lordship will take a call on that. my lord.
Proportionality, I have to remand it back because that is one punishment if I hold it. As I am saying that there is only one punishment.
Yes, my lord.
So therefore I have to remand it back.
Remand, my lord. The law will say so. And
One
otherwise,
has to, you see, we can't put both at the same, the Nazir as well as him at the
my
same
lord,
time.
otherwise also, my lord, in the subsequent DP, my lord, he has been awarded with punishment of compulsory retirement.
And in that DP, the allegations were serious because there he tried to bribe the judicial officer for appointment of a person, in the subsequent. Now
No,
he is compulsorily retired, But
My-
I'm not,
my lordship,
I'm
that
not
is a
trying to
different-
influence, Lordship may
that
not
is my lordship,
be
with
influenced
regard
with
to
that.
this.
But
And
on the
in
last
that
occasion,
DP,
Lordship
my
read it.
lordship, I have stated in that DP, this DP reference was made, my lordship. And my lordship might remember, for that, my lordship has
Since
given
the
one
petitioner
interim order.
brought this before your lordships, the
Because
subsequent
I
DP.
need to bring because
Madam, I'm
I-
not going to look into those.
my lordship. I understand.
My question is only restricted
Yes, my
to
lordship.
this brief.
Yes,
No,
my
this lordship will take a call,
I'm,
So
I'm
far as
only on this.
crucialty is
My
concerned-
only question was qua the Nazi. The
Yes.
Nazi should be, the punishment of the Nazi can and him cannot be same.
And so he is
No,
not
it's
before this
different
court.
because pay scales are different, my lord.
No,
So
that is-
Yes.
therefore, cannot be same. So
No, no,
therefore, on
different.
the very proportionality, I have to interfere and asking them to give him a minor punishment. Any one of these 7, 1, 2, 3.
I leave it to your lordships.
Is something, the mistake has been committed, but the mistake is not so egregious to consult a major, unless because there was an apparent mistake on the part of the judicial officer. That I'll put it.
And my lordship, one submission
Hmm.
with regard to my lordship is aware, whenever any execution proceedings are filed, it has to be referenced with regard, not with that judgment. It has to be with the regard to the degree or the execution case number has to be there. Here, apparently nothing was there, my lordship. My lordship is aware of that part, that whenever any execution case is filed, we have to state a judgment decree, and along with the execution case number has also to be filed. That was not done here. Neither any order was passed, my lordship. And my lordship, in this regard, I just give it, if something, my lordship, in that case, whether in that case of advocacy, it's very easy for my junior to correct me, but whether my brother will be able to correct my lordship. So same is the case that happened in this case. It's not possible that my brother has been insistently telling in every submission that he was aware, he should have informed. The thing is that whether my lordship is aware of the court rules, my seniority, and like he is only to that extent, whether he can correct a judicial officer in that regard, my lordship. And moreover, my lordship, execution case number was not referred, my lordship. So being in this position, it is easy for her or my brother to correct. But whether my lordship has to see that aspect also, whether in that position, whether he can correct a judicial officer, because he was only to that aspect, my lordship. And with regard to proportionally, with regard to Nazir, he is not before this court.
Is there any civil rules or miscellaneous rules by which the duty of the officer, of the assistant, miss assistant, or the execution assistant have been mentioned?
Lordship, but asks others.
Because what has happened, you see, in the Seristadar, there is a mention.
No, so far as my lord, regarding merits of the case is concerned, lordships, on the last occasion, I placed the records before your lordships, my lord.
That is not
There are
there.
two-
I'm not on
two
that.
witnesses.
Whether there is a rule. You see, if you see the civil rules and orders, you
Yes.
see what is the duty of the civil Seristadar.
Somewhere in the enquiry report, so far as remember, the enquiry officer made mention about this, my lord. I'll just check, my lord.
And my lordship, with regard to the evidence of Swapna Chakraborty,
Yeah,
my
you see,
no, it's not a-
we'll take it up on another.
Oh.
Only that aspect you see it, nothing more. Otherwise, I'm convinced of passing the order, but today I didn't get the time.
Lordship.
We'll have it when? In fact, today was not a Thursday. When can you get it, me? Because what is the duties of the miss case of a miss assistant or this? Is it prescribed anywhere? Because that is a very important aspect. If a duty, you have to be, there is a duty. And if you are in violation
That
of the
issue is not
duty,
in dispute. That he was an executing assistant, that is not in
whether
dispute.
it is his duty to inform, because there is no order of tagging.
No, no.
Normally, Mr. Das, kindly listen. There has to be an order of tagging. Normally, as we have done in civil courts, we have seen whenever the petition is given, an execution petition is given, there is an order of tagging. This tagging should have been done by passing an order. That was not
No,
done.
that is all along the case of the petitioner.
No.
Along with-
Now, my question is
Yes.
whether there is a necessity
for the miss assistant or the execution assistant to do that. Or inform the judge. Because that is a very important aspect, whether it is necessary. You see, it is a dereliction of a duty.
There has to be a
Yeah.
duty.
There has to be a duty.
There has to be a duty, then only there will be dereliction. Lordship
Dereliction.
is correct. But from the records which I.
No, no, not on the records. My question is, so therefore, if there is a dereliction of the duty, then you can.
Here, if I have understood correctly, the inquiry officers.
Or if he has hidden,
negligence.
if there are evidence that this order was hidden.
No,
That
no,
is not the
correct.
case.
Lordship is correct. The inquiry officer says that he was negligent and because one of the witness.
Grossly.
That is.
So
lordship will
therefore, my question is, you just find out that. You find out.
Yes, my
Because
lordship.
in the civil rules and orders, what are the duties of each are mentioned. Okay?
Yes, my lordship.
We'll have it on another day. Next matters on August.
Next to next.
No, on next Thursday, my 18th, my lordship.
No, not 18. 20, lot of matters. 20 lot of matters. 18, 7 matters.
My lord.
18 can be taken.
18. At my lordship at 2. Yeah. My lordship may give that
Yeah,
at or else it will not reach.
Today,
My lordship,
Well,
my
this
lordship may
2-3
give,
business has
no,
regard.
today,
my lordship may kindly give that at or else my lordship.
no, add two kori.
Yeah.
Today I am.
No, it was an hectic
My
day,
court is
Yes.
behaving like the Indian Railways when we were in college days.
Yes. No.
Oblige, my